Welcome to the Foul Play YouTube channel.
Greetings and salutations, everyone. Sorry I'm late, or we're late. I had to get coffee, though. That's really important.
Yes.
Welcome to Open Mic 115. And we're back into the Colborn.
Starring Jack and Rhonda.
Yeah, we're flying kind of duo right now. So Cherie's got things to do, and I know Doc's got some stuff going on. He's going to try to jump in here in a bit. I don't know where Alice is. The dog may be walking her right now, but it's and Susan Sugar, it is her birthday, so I'm not sure if she's coming or not. So we'll see. But anyway, we've got a couple of documents, and we'll get to them here in a minute. But Rhonda can say hello and talk them into if she wants.
Well, you know how much I love to talk, so I'll just say hello to my panel member, Jack, and my online big brother, my internet big brother, and hello to everybody in the chat. We kind of got started a bit late, partially because Jack needed a fresh cup of coffee, partially because he forgot he had scheduled for 4:45 or 5:45, and kind of maybe a little bit because we were hoping some more people would join us on the panel. So
kind of all the above. So yeah, I give him a little extra time, but I actually did forget. I put this one for 15 minutes early, but hey, we've only got 2 documents. They're not super long. They're not super long, so it shouldn't take too much time, depending on what conversation we get into. But first, let's say hello to everyone in the live chat that we can see so far. I see the lovely Power Mod, Super Mod Dark Side. There's Case 10 reporting in from, I don't know where he's traveled to now, with his combine and so forth. I think they're all done. There's JD. There's Phaedrax. He just joined. Phaedrax. I hope I'm pronouncing that correct. Who else we got here? There's Pete Moss.
Sorry, I'm reading the chat and giggling at the comments
that's
about me. Oh.
There's Master Cedar. Hey, thanks for coming, West Virginia.
Catnip. Oh, sorry.
Oh, is Catnip there? There's Catnip. Yep, we see her.
Yeah, she just dropped in.
Cat, you and Darkside can come to the open mic Discord, and you don't have to talk. You can stay muted if you want. It's entirely your call, though. It's up to you.
Yeah,
hey, there's Ron. Yeah, there's Rhonda SD and Andy B. Thanks for coming. And that's all that I see so far. Oh, there's iced coffee.
Oh. I prefer hot coffee, but that's okay. Any kind of coffee is good right now.
There's Clive. He came in, and there's no way to see, unless somebody types. We have no way to see, but who else in the chat, and that's fine. A lot of people like to work and just listen, so that's okay. That's okay.
Yeah, I just have to say, Anthony Hill said, because I am very self-aware. I know that I am a chatterbox. My mother used to call me Chatty Cathy. She bought me the doll Chatty Cathy for Christmas when I was younger because I talk, and I sometimes don't even make any sense, but I still talk. Well, Anthony Hill says Rhonda doesn't talk as much as Silkman. I don't know about that. Maybe I just don't make as much sense as Dr. Silkman, but I think I definitely can out-talk Dr. Silkman. I just try really, really hard not to. And then Phaedrax said, Rhonda giggles more. Probably true too.
Yeah.
I am a bit of a giggler, so, be worse. I probably swear more than Dr. Silkman does on when we're in lives and stuff. But, I also, for some weird reason, try to hold back on my amount of swearing for some reason. I guess because I know I cannot be outsworn. I mean, I'm
Well,
going to be outsworn by Alice, so it's just like, what's the point?
well, there's and I guess everybody's kind of aware of this, but things have changed with YouTube over the last couple of years, and I try my best not to drop the f bombs and so forth. But when when you're monetized and you're going through and submitting, there's a series of questions and they've expanded that now. It's like when I took over streaming from Zoe. I mean, there was like 4 or 5 sections that you had to go through to check off that if you did this, you kind of have to mark your video so it's appropriate for whatever advertising they're going to tag with your video. So you have to answer these questions, and typically, and there's one section for sweary words, nothing. And typically that's fine, and it does. You're not restricted in any way. Your advertising is not restricted. However, you can go. There's other ones that boom, you're limited ads, and and they also, if they run their little algorithm thing, and I don't know what it does, but it can detect and it can kick you and give you limited ads. So it's I try to not do it, but if it comes out, it comes out, and I'm okay with it.
Well, or if you're like me and your channel only has 348 subscribers, you are not monetized. You could say a whole lot of swears.
Oh yeah,
and nobody says anything.
unless somebody reports you, then that's a different question.
Yeah. That's
But
true. When the virtue signalers. Oh, sorry, that was a political comment. When those that are very. Oh, never mind. There's always somebody who's got to complain, right?
I was just gonna say, yeah, but this is an adult channel. We've talked
Doesn't
about that
matter.
before.
Yeah.
This is an adult channel. We don't gear anything really towards children. Not that we don't love our children, but it's
Right.
they can get on their own channel later or listen to us, after they're adults. So
Yeah.
all right,
Exactly.
I'm going to load up the first document. We've got 2 left, as I said. Document 356, which we're starting on, and 357, and neither one have attachments. So
Woohoo.
this is the first. It's 22 pages, and we'll get through these. And depending on where we land on time, I'm going to play 1, maybe 2 audio calls from MTSO at the end later on of Avery of Colborn. So anyway, Rhonda, if you would, like I said, this is 22 pages. And if you want to start reading, I'm glad to help. You don't have to read the entire thing. If you want to take a break and whatever.
All right. I only need to take sips of water at the most inopportune times. Other than that, I
Okay.
should be okay.
Okay. All righty. Well, you just start whenever you're ready.
Okay. Okay. Let's see. Defendants, Chrome Media LLC, formerly known as Synthesis Films LLC, Laura Riccardi and Dora Moradimos, reply in support of motion for summary judgment. Introduction. The parties' summary judgment papers reveal a sharp contrast. Defendants are asking the court to watch Ma'am and judge the series for itself, whereas plaintiff continues to bombard the court with supposed summaries and editorialized addendum purporting to recount Ma'am's contents. Plaintiff ignores that the case is no longer at the pleading stage and his allegations about Ma'am are no longer accepted as true. It is summary judgment, and the First Amendment requires courts to, quote, make an independent examination of the whole record so as to assure itself that the judgment does not constitute a forbidden intrusion of the field of free expression, end quote. And that's cited in New York Times versus Sullivan, 1964. As the Wisconsin Supreme Court has stressed, This duty entails a constitutional responsibility that cannot be delegated to the trier of fact. Summary judgment is an important and favored method for adjudicating public figure defamation actions. That's Torgeson v. Journal Sentinel, Inc., 1997, Wisconsin. Internal quotes were omitted. Viewed as a whole, both Mam and the record show that plaintiff's claims fail as a matter of law. Plaintiff has tried mightily to make this case seem more complicated than it is, but straightforward application of well-established law shows plaintiff cannot meet his constitutional burdens of showing material falsity or actual malice by clear and convincing evidence. The court should grant summary judgment in favor of the producer defendants. 1. Plaintiff fails to connect his arguments in his opposition to the claims actually pleaded in his second amended complaint. Rather than substantiate the claims he pleaded, plaintiff's opposition papers consist of criticisms of Mam disconnected from his second amended complaint. 25 pages of the opposition plus an unauthorized 7-page addendum purport to summarize Mam in violation of the best secondary evidence rule. Joint response to CAPFF general objection, aside from being one-sided, his quote-unquote factual background and addendum are riddled with obvious inaccuracies, underscoring why the court must view Mam for itself. Plaintiff also fails to explain how his criticisms of Mam relate to, let alone substantiate, the allegations and elements of his claims. In opposing summary judgment, he has provided admissible evidence showing specific statements on which the second amended complaint is based are materially false and made with actual malice. He did not do that. His scattershot opposition not only lacks evidentiary support, but essentially left it to the court and defendants to connect the dots between the allegations of his complaint and his opposition papers. Accordingly, plaintiff has not sustained his burden on summary judgment of substantiating his claim. Is that a footnote? I'll read the footnote. See also Independent Towers of Washington v. Washington. When reading ITOW's brief, one wonders if ITOW, in its own version of the spaghetti approach, has heaved the entire contents of a pot against the wall in hopes that something would stick. We decline, however, to sort through the noodles in search of ITOW's claim. As the Seventh Circuit observed in its now familiar maxim, judges are not like pigs hunting for truffles buried in briefs. That's pretty.
Oh my God, that's fantastic.
That's pretty amazing.
It is.
It's pretty fucking amazing. Sorry, I just had to put it in there. Man, and this has got to be it's got to be Lita Walker because this is just epic already.
Mm-hmm.
Okay, 2. The opposition confirms summary judgment is merited based on lack of material, falsity, substantial truth. A. Plaintiff cannot escape the governing law, which bars his claims. Plaintiff erroneously claims Global Relief Fund, Inc., the New York Times Company, does not apply. His desire to avoid the case is understandable. It bars his claims. While Global Relief applied Illinois law, its principles are based on the First Amendment. Global Relief primarily relied on a decision, Gist versus Macon County Sheriff's Department, which emphasized that the substantial truth doctrine, quote, is rooted in the United States Constitution, end quote, and relied on Sullivan and Mason v. New Yorker Magazine, Inc. Indeed, this court noted the applicability of Global Relief. although plaintiff ignores that. Recently, the Seventh Circuit, applying Wisconsin law, affirmed summary judgment in favor of a defendant newspaper for lack of material falsity based on the same principles as Global Relief's, and that has to do with the financial fiduciaries case. There, the defendant's article said Batterman was accused of mishandling funds, committing wrongdoing, and putting Geisler's money in jeopardy. And these statements, as the district court correctly found, were fully supported by court records in which those accusations were made. Plaintiff does not try to distinguish financial fiduciaries. Let's look at that footnote. Footnote 2. Other circuits have reached the same conclusion. For example, Edwards v. National Audubon Society, Inc. And that's just citing some cases. Let's see. I'm going to go back up.
Oh, they were just citing a case. Okay.
Yeah, they were just citing a case. So I'm going to go back up.
It's where it says the Wisconsin Court of Appeals.
Gotcha. Thank you. The Wisconsin Court of Appeal reached a similar conclusion in Erdman v. SF Board of Green Bay, Inc. The defendant, represented by plaintiff's counsel here, prevailed on summary judgment at star 8. I'm not sure exactly what the star indicates here.
I think that's probably a page or a section, I'm guessing.
Yeah, something. They prevailed. The court explained that, quote, while the facts the police provided to the media ultimately proved to be untrue, the television report accurately reflected the information law enforcement publicly disseminated. Erdman does not demonstrate that any portion of Channel 11's report was not a fair statement of the information the police publicly disseminated. Plaintiff's opposition fails to address Erdman despite his counsel's personal familiarity with the case. Okay, there's similar and familiar are hard words for me to say. Plaintiff, let me read the footnote 3, sorry. Footnote 3, plaintiff cites an inopposite case, Prohl versus Brosamley, in which a court declined to find substantial truth because the defendant's story falsely stated that the plaintiff had been charged with a crime when he had not been. Nobody in MAM says plaintiff was charged with a crime. While MAM includes Avery's planting allegation, the second amended complaint concedes Avery's attorneys accused plaintiff of planting. MAM accurately reflects that accusation and is thus analogous to Erdman, Global Relief, and financial fiduciaries, not Prohl. Plaintiff's theory of republication liability ignores this governing law. He relies on inopposite cases on subjects like spreading private rumors in contexts very different than MAM's coverage of legal proceedings of great public interest involving accusations of governmental wrongdoing. Let's go to footnote 4. Let's see, it's a bunch of case sites, and then it says defendant sent letter to plaintiff's supervisor about abuse allegations from his ex-girlfriend. Okay.
Yeah, they're citing that case, Hart v. Bennett, and they're talking about that. Yeah.
Okay.
His top of the page, his theory of liability.
His theory of liability would radically transform First Amendment law, leaving the media unable to cover contested legal proceedings of significant public interest without the threat of liability for informing viewers of parties' underlying contentions. Plaintiff cites Mason, but it supports defendants. Mason sets a high constitutional bar for material falsity. A statement need not be precisely true in all details. It is sufficient that the gist and sting are accurate. A plaintiff must prove specific challenge statements create a different effect on the mind of the reader from that which the pleaded truth would have produced, and such differences must bear upon their defamatory character. Pardon me. While
You're fine.
Mason found triable issues for certain statements, they, quote, involved the fabrication of quotations, end quote. For example, quote, an author who, with full knowledge of the inaccuracy, used quotation marks to attribute to plaintiff comments he had not made, end quote. Defendant portrayed the plaintiff's, quote, in a most unflattering light, end quote, though fabricated quotations claiming he had referred to himself as an quote unquote intellectual gigolo, trying to turn the Sigmund Freud archives into a quote a place of sex, women, and fun, end quote. And that other analysts would say in response to his forthcoming book that, quote, after Freud, he's the greatest analyst who ever lived, end quote.
Intellectual gigolo. Oh,
Intellectual gigolo. No, I'm
yeah.
gonna
Did Lita
I'm
write
gonna have
this?
to Google that.
Yeah, absolutely.
Somebody Google that for me because I want to know what that is. Intellectual gigolo. That's interesting. Okay. Um, I should probably get a straw to drink through so I'm not slurping your water in your ears.
You're fine.
Intellectual gigolo.
I didn't even hear you actually.
Okay. Okay. Good. By contrast, plaintiffs' criticisms of MAM relate to second-guessing the producer-defendant's editing decisions in condensing plaintiff's 3+ hours of trial testimony to approximately 11 minutes of his testimony appearing in MAM. Mason acknowledged, quote, the practical necessity to edit and make intelligible as speakers. Wait, sorry, I'm not understanding what I'm reading. The practical necessity to edit and make intelligible a speaker's perhaps rambling comments, like I just did. I think that's what they're talking about, end quote. And the facts that a subject's, quote, full and exact statement will be reported in only rare circumstances, end quote. Mason stressed that even when dealing with fabricated quotations, there's no libel unless the plaintiff shows alterations, quote, gave a different meaning to the statements, bearing upon their defamatory character, end quote.
Footnote 5.
Footnote number 5. Plaintiff resorts to a straw man argument in falsely referring to defendant's claims of unflattered discretion to edit. And defendants claim no such thing. Their moving papers explained in detail why the editing at issue in this case comports with governing law. Yeah, that was good.
Was.
When you read her side, when you read Netflix's or, their side, it just makes sense. But when you read stuff from Andy, it's just
You don't know
intellectual gigolo
you don't know what you're
mumbo
gonna
jumbo.
get. It just comes across bad and bad lawyering and in this everything that she's written or whoever wrote this, if it was Kevin, even he's pretty damn good. I have to admit.
Yeah, that's true. That's true. Plaintiff fails to show that here. Instead, large swaths of his brief addressing substantial truth consists of unsupported assertions lacking specificity or citations to evidence. Much of his quote unquote material facts section cites only to his addendum, which is not evidence and violates the secondary best evidence rule. Footnote numbers. Unlike here, the plaintiff and Mason also presented substantial additional evidence that could support a jury determination under a clear and convincing standard that The defendant definitely or deliberately or recklessly altered the quotations to defame plaintiff. Wow. Plaintiff also misstates the relevant legal standards with regard to their fair report privilege, which courts often apply in conjunction with the substantial truth material falsity requirement. Plaintiff cites let's see. Plaintiff cites
They
to
quote that
American Journal footnote
they
7. Huh?
they quote that thin fiduciaries quite a bit. Maybe at some point,
Yeah.
I may ask Cherie if she has time to. She can just take a quick glance at Westlaw or whatever. I don't know if she can do that or not, but maybe we can look it up. But her legal,
well, we can.
her legal, she can, she can probably find something quicker than we can and get us a quick summary because they quoted a lot. Anyway, I didn't mean to interrupt you.
No, that's okay. That's fine. So plaintiff cites to American Journal footnote 7 and a 19th century case, Buckstaff v. Hicks, Wisconsin, 1896, claiming the fair report privilege only applies if the defendant acted in good faith and without actual malice. So footnote 7 says, plaintiff's American Journal citation does not support his argument, but instead echoes the principle applied in global relief and financial fiduciaries. Quote, what is important in considering whether the privilege has been abused is not whether the underlying charges are true, but whether there was a fair and accurate account of the proceeding, end quote. And that's in the American Journal. Looks like second edition on libel and slander. That's interesting. I might like to look at that.
Statute 300. That is interesting.
Yeah. Yeah, that sounds interesting.
Where the hell's 7? Now I've lost my place here. Where the hell's 7? Oh, I see it. I see it up here.
Okay.
Yeah.
You got it? Okay. It was premised on a long outdated understanding of how the First Amendment applies to media coverage of public proceedings. Case sightings.
More citations.
More citations. And holding that under the First Amendment, a newspaper cannot be liable for accurately reporting that a public figure was accused of blackmail at a city council meeting, even when the reporters knew that no extortion had occurred. B. Going to take a little sip of water.
You just get yourself a gulp there. It's fine.
Well, it's a dry mouth medication situation that I live with, so
I understand.
Okay. B. Ma'am accurately captures the gist of Avery's accusations and plaintiff's denials. Good Lord, we're going right down to the footnote 8. While the Seventh Circuit apparently has not ruled on the issue, the majority of jurisdictions that have done so require a public official plaintiff to prove falsity by clear and convincing evidence. Holding plaintiff failed to carry his burden of proving by clear and convincing evidence that Draven's statements were false. Here, plaintiff cannot meet his burden under that standard or the preponderance of evidence standard.
I agree with that.
Yeah, that's right. 1. Plaintiff cannot conflate the viewpoints of ma'am's subjects with those of the producer defendants. Plaintiff's opposition continues to do what Global Relief, Financial Fiduciaries, Erdman, and the other cases do not permit. Conflating contentions of participants in the underlying controversy with supposed statements by defendants documenting it. The opposition papers repeatedly assert, quote unquote, ma'am says, or quote unquote, defendants state. But the defendants do not appear in ma'am, and ma'am does not include voiceover narration. Instead, it lets the documentary's various subjects voice their own viewpoints in interviews, press conferences, hearings, and in arguments and testimony from Avery's and Dassey's trials. Moreover, ma'am includes both Avery's and his defenders' allegations and also plaintiffs' and other law enforcement officials' other law enforcement officials' strenuous denials, as well as scores of scenes reflecting negatively on Avery. The law is clear that MAM must be considered as a whole and that its presentation of both sides of a contested issue is not materially false endorsement of the truth or falsity of either side's allegations. Footnote 9.
See, before you read
See,
that, before you read footnote 9, what they set up here is exactly what we talked about the other night, because I noticed in their plaintiffs, some of their last several, they're trying to make MAM a person, and MAM is not a person. It's not an entity. It's a presentation of a bunch of different people, and then talking in their opinion, whatever.
Right.
I think that was I think that this is really well said what they said in this section I highlighted there. So anyway, footnote.
Yeah. Okay. Note 9. It recommends that we see financial fiduciaries, which we plan to do, Global Relief, Erdman, and Riley v. Haar. Now they're adding more. Woo. Reasonable readers would consider statements in a book written in an attorney's voice as statements by attorney, not the author, and not as assertions of fact by author whose book covered the trial in which the attorney participated.
Exactly.
But and you read some of these little footnotes or even some of these sentences or paragraphs in the actual document, and they make it make even more sense why this case is so
ludicrous.
So much a waste of time.
It is.
Yeah, it's crazy. All right. Plaintiff's opposition claims that MAM created a storyline and conspiracy theory narrative, and that MAM may as well have included a neon sign announcing Andrew Colborn is the officer who planted evidence to frame Stephen Avery. That's funny. See, that sounds like Lita Walker to me.
It does.
But MAM could not document Avery's trial without reflecting that, as plaintiff's second amended complaint puts it, a central part of Avery's defense at trial was that plaintiff and other Manitowoc officers planted evidence to frame Avery. Emphasis added.
And we got a footnote right away.
Footnote 10. Yep. Footnote 10. Plaintiff tries to walk back his second amended complaint's clear-cut admission at times, perhaps because he now realizes it is fatal to his claims under global relief and financial fiduciaries. But he repeatedly made similar admissions regarding the centrality of Avery's planting allegations and the transcript and orders from Avery's trial. I read that incorrectly. Avery's planting allegations and the transcript and orders from Avery's trial confirm it. Sorry about that, guys. Avery's planting allegations were so central to Avery's trial that both sides' closing arguments addressed them.
And don't forget, before you start back, remember, it was, I don't remember which open mic it was, but it was probably a couple weeks ago. We were reading Colborn, another excerpt from Colborn's depositions, and he would not admit that the planting allegation was a central part. He kept on slopping it off and trying to deflect it. Mm-hmm. He would never admit to this. He had to know. It's such crap.
Yeah. I see that Catnip posted or put a link in referencing, it looks like financial fiduciaries. The chat jumped, and so now I don't know what it was.
I've got it.
This is the case that that references intellectual gigolo, Mason v. New Yorker. Okay. Oh, cool. Thank you, Kat. Appreciate that. I already have Discord. Okay. Don't need to follow the other link. All right. Number 2, MAM's edits retain the gist and sting of plaintiff's testimony. Plaintiff complains about 2 types of edits. some that do not repeat or underscore points as much as he'd like, and others that substantiate similar responses and reactions for the originals. Ma'am,
call,
yeah,
call their ass out on it. Good. Go ahead.
yeah. It's like, we see you're cherry picking.
Yep.
Oh, okay. Ma'am necessarily had to cut down plaintiff's 3+ hours on the witness stand to fit into a 10-hour series covering 30 years of events, including Avery's trial with dozens of witnesses. This need to compress is why Ma'am did not include repetitive exchanges. Also, as the producer defendants explained, access to usable footage of trial witnesses was an issue due to undetermined feed. Is that the right? Am I saying that word right?
Unterminated.
Unterminated feed at the courthouse okay. Those are different documents. The producer defendants made concerted efforts to substitute comparable footage of witnesses responding, listening, and waiting with the footage available to them. The unusable, unterminated feed footage. Let me start that over. The unusable, unterminated feed footage problems are why raw footage does not always precisely match certain moments in Ma'am, but as Ma'am and the evidence, including the raw footage, show, the differences do not alter the gist of plaintiff's testimony.
Thank you. That was so perfectly said.
I don't know why I'm struggling to read tonight. It's not normal for me to have this much trouble.
You're doing fine.
My brain's frozen.
Yeah, it's pretty cold there too. So yeah, we were talking about that. It's cold as hell here.
I realize my weather's not nearly as bad as some in the West and Midwest, and I'm really sorry for all of you out that way. But we were without power here at my house for most of the day yesterday. My brain is still trying to warm up. I'm going to use that as an excuse.
Works for me. I do it. I've done it before. Yeah.
That's good to me. Okay, number 3. Ma'am accurately captures the gist of plaintiff's jail call testimony. Many of plaintiff's complaints about the jail call relate to items he admits are included in Ma'am, but which he would have liked covered in more depth or repeated for emphasis to make him look better.
Right away to footnote 11.
Footnote 11. For example, in document 327 at line 50, while this was previously stated for, omitting testimony that further underscores the internal consistency of Mr. Colborn's testimony, complaining about non-inclusion of question about way back in 1994 or 1995, although previous questions had already asked him, quote, about the 1994 or 1995 telephone call, end quote. Complaining Ma'am does not include his testimony that he answered the jail call. Quote, Manitowoc County Jail Officer Colborn, end quote. Even though Ma'am includes his testimony that he received call, quote, when I was working in my capacity as a corrections officer at the Manitowoc County Jail, end quote. And then at 56, he's complaining Ma'am did not include more of his deposition testimony.
Jesus Christ.
You can't make this guy happy. Shouldn't have used it. You didn't use enough. You should have used this part instead. What an idiot. That is no basis for material falsity. Lacking material criticism, plaintiff resorts to quibbling. He complains about a substitution of no, I don't for no, sir, which Demos explained was made because of the unterminated feed. He gripes that although, I love the words, Ma'am includes his testimony that he transferred the caller to a quote unquote detective, It does not include additional testimony that he transferred it to the, quote, detective division, end quote. Although he admits Mam includes testimony that he did not know if the jail call was even about Avery. He complains it did not include additional testimony that, quote, no names were given, end quote. But if he did not know if the call was even about Avery, the caller obviously did not provide names. He criticizes Mam for accurately documenting that he did not write a report until 2003, but not including that he did so after Sheriff Peterson ordered it. However, he fails to identify any material falsity. Plaintiff concedes Mam includes him testifying why he did not prepare a report in 1995. Quote, I don't know what it would have been about, end quote. And quote, if I wrote a report about every call that came in, I would spend my whole day writing reports, end quote. Yet he criticizes Mam for not including additional testimony to the same effect. He criticizes Mam for supposedly not including his testimony about the jail call. Quote, no, I'm not ruling out the possibility that I may have discussed it with someone else, end quote. And let's go to footnote 12.
Oh, yep. We didn't even get to read anything, or automatically at a footnote.
Yeah. Okay. Yeah, I know. Yeah, it goes right from the document number to the footnote. Footnote number 12. Plaintiff ignores that Mam includes statements that after he forwarded the jail call to a detective, plaintiff was given, quote unquote, reassurances by someone in the sheriff's office, some said Kuceric, that he need not worry because they already had the right guy. That refutes the idea that plaintiff, rather than Kuceric and Vogel, the defendants in Avery's suit, is presented as the one Avery blamed for lack of follow-up. But Mam includes his testimony making that point. Quote, I may have mentioned the jail call to other people, but I don't recall doing so. Which I always thought was ridiculous. I may have done it, but I don't remember it.
I don't recall it.
Okay. Footnote number 13. While plaintiff suggests Mam should have included a disclaimer that testimony was edited rather than abridged, Mam informs viewers that Avery's trial lasted more than 5 weeks, whereas Mam devotes only a little over 2 hours to the trial. Mam also cuts between direct and cross-examination, making it clear that viewers are not watching reel-to-reel C-SPAN coverage. No reasonable viewer could be surprised that Mam condensed and edited testimony, and the law did not require Mam to, quote, state the obvious, end quote, with disclaimers. And it cites to Campbell v. Acafros Music, Inc. Defendant, in this case, defendant could invoke fair use despite not expressly labeling work as parody. In Texas Beef Group v. Winfrey, it is common knowledge that television programs cut down longer footage to fit into a shorter time frame.
Absolutely.
But
yeah,
but Andy doesn't understand that.
No. Hey, I want to welcome Alice to the Discord chat. Hey, Alice, how are you?
Guys, yeah, I'm doing good, thanks. My son popped out for a surprise visit, so I was very happy to see him. So yeah, that's why I was a bit late.
And today's his birthday, right?
No, that was a couple of weeks ago. His birthday was the 3rd.
Oh, okay, yeah, okay, yeah.
Oh, I have a grandson's birthday on the 3rd.
Yeah.
Yeah. Yeah, well, yeah, it's great to have you, Alice.
Absolutely.
Yeah, good to be here.
Yeah. Let's see. Are we at number 4? Yes. Number 4, Mam accurately captures the gist of plaintiff's call to dispatch testimony. Plaintiff admits that Mam shows him denying multiple times that he was looking at Teresa Halbach's car when he made the call to dispatch. Yet he complains Mam also shows Avery's attorneys efforts on cross-examination to cast doubt on his denials, despite those efforts being an integral part of the trial. For example, he criticizes Mam's inclusion of him erroneously claiming that the dispatch operator provided him with the information about Teresa Halbach's car, even though he concedes that occurred at trial. He complains that whereas he testified that, quote unquote, obviously, he got information about Halbach's vehicle from Calumet County Mark's Wiegert, Mam conveys that by showing plaintiff's testimony that Wiegert, quote, had to have given it to me because I wouldn't have had it any other way, end quote. None of these complaints show falsity, let alone material falsity. Plaintiff's primary complaint about the call to dispatch involves compression of a portion of Avery attorney Strang's cross-examination. As in his second amended complaint, his opposition presents that compression out of context. He ignores a prior back and forth between him and Strang, which Strang drew on when he rephrased his question following an objection. While the wording of Strang's two questions may be different, the gist is the same, especially in context. Strang was suggesting the recording of the call to dispatch sounds like one of the frequent calls plaintiff had testified about earlier, where he had been looking at a car's license plate when calling dispatch. Strang was implying he had also been looking at Teresa Halbach's license plate during the call, and plaintiff denied that. Mam does not materially change the gist of the exchange. Plaintiff is wrong that Mam suggests that he admitted he was looking at Halbach's car. Mam shows him expressly denying that. Also, the fact that someone without personal knowledge of the underlying facts might think from the audio recording that plaintiff was looking at Miss Halbach's car would not contradict his testimony that, in fact, he was not. Nor would it constitute a damning admission by plaintiff, particularly in light of Mam's inclusion of his repeated and explicit denials.
I have to comment here, and I'm going to play this call when we get done with this document. But what I got when I remember when I originally watched Mam, I didn't necessarily, because I didn't know anything about the case. I mean, other than what I was learning from the docuseries, I didn't necessarily get the gist from his testimony and what they showed that he was looking at it. He denied that he was there, but it was the way he acted, his mannerisms that made me think that he might have not been telling the truth. It wasn't what, right? I don't know if I'm conveying that properly, but hopefully I am.
I felt the same way. I understand what you're saying, because I was feeling the same way. I just like, I might have just watched you or listened to your testimony and, not been sure one way or the other. But when I look at you,
correct. His mannerisms, the way he conveyed, no, I was not, I wasn't sure, but it wasn't Mam that did it. It was him.
Exactly.
Yeah.
Yeah, that's
I was exactly the same. Yeah.
Hey, there's Dr. Silkman too. Sorry, go ahead, Alice.
No. Just I was just agreeing that it was him that did it. The way his mannerisms were, the way his reactions were, the way he looked shady, and no matter what, he looked shady. And as you say, his reactions and the way he was acting and things like that on the stand didn't add up, you know what I mean? So
right.
He looked shady, definitely.
I was going to say,
Doc, you want to say hi and give a comment?
It's good to be here, Jack61 and fellow panel members and everyone in chat. Sorry I was a little bit late, but life happens and you got to get things done. But you're 100% correct, Jack61. There's no way that the filmmakers or anyone else in that courtroom made Colborn react in the manner in which he did, right? So he reacted that way. Not the people taking pictures or video. Had nothing to do with Netflix whatsoever. It is all self-induced. And you know what didn't help Colborn when he said about the fact that, well, look, how else was I going to get this number plate? It had to be from Mark Wiegert, right? Mm-hmm. And remember Mark Wiegert? Wiegert did not look at Colborn, but looked down. Right, as if to say, shit, did I really say that? And that didn't look good for Colborn.
No.
So Colborn can't complain and say, hey, you've done all this shifty editing. It's Colborn himself, right? And so he made himself look very guilty. And people looking at it thinking, jeepers, was he really looking at those number plates? So for God's sake, the judge here, Judge Ludwig, is going to say, come, are you now trying to tell me that the filmmakers made you react in that manner? Come on.
Right.
Exactly.
Yeah, he did all of this to himself, honest. I mean, he can blame Netflix and the producers and the writers and Ma'am and everybody all he wants, but he really did all of this to himself. So I have no sympathy for him.
Hey, we've had a few more join before you start reading again. I wanted to welcome Mose Call. He's here. Crockett, our William. I thought I saw another one here.
Our William.
Yep, I said our William and Paul Ward. I think he's joined.
Oh, there's Susan.
And Susan, happy birthday. Happy birthday to
you. Happy birthday, sis. She just got home from work, she says.
Awesome. Well, jump on in whenever jump on in if you want to come in and chat a while there, birthday.
Yep. Everybody tell Susan happy birthday.
All righty. Continue on whenever you're ready.
Okay. Okay, excuse me. Number 5. Ma'am accurately captures the gist of plaintiff's testimony about the key.
You didn't read footnote 14.
Oh, I didn't? Oh.
No.
Okay. Footnote 14. Plaintiff's reliance on inadmissible, unauthenticated, anonymous voicemails and internet posts does not change this. He admitted at deposition that, by definition, the anonymous people who left him abusive voicemails were unreasonable.
There you
go. Yep. He just didn't know how. It's like he forgot. This has gone on so long, and there has been so many documents and so many briefings and so many filings that he has done that it's like he forgets what he said in the last one regarding, the same issue. And he just doesn't make any sense.
Like it's bad lawyering. I can't imagine Lita Walker or Kevin Bick, and you guys can comment as you will, but I can't imagine at this point that they wouldn't say, "Look, we need to drop this case because you don't have anything. We have nothing. We're just repeating something that we can't prove at all, and it's not against what they've done doesn't break any laws."
But it's actually. Sorry, just Rhonda.
No, go ahead.
I was going to say it's actually worse than that because he's lumping, Colborn is lumping everyone who responded negatively to him as part of Ma'am.
Yeah.
Right?
Yeah.
So he's now, I think someone made the comment that Ma'am is like a person. Was that you, Jack61?
That was
that's what they tried to do in the last, I'm going to say probably 3 or 4 of their submitted motions or whatever the hell. They've tried to create Ma'am as a person and that Ma'am did this and Ma'am did that. And that's just, it's wrong.
Correct, correct. And now he's trying to blame individuals who have responded negatively to him as all part of the MAM conglomerate and MAM conspiracy out to defame Colborn. Do you see what I mean? Like, he's now gone beyond the documentary and has now roped in probably even YouTubers. Anyone that's made a negative comment, he's lumped it all together as being part of MAM. And the judge is going to look at this thinking, oh my God, so is he now potentially suing the entire society that was negative against him?
Yeah.
Right?
Basically.
It's crazy. It's the problem with his civil suit is that it's non-specific, and that's a danger.
I agree.
Yeah. Comment by Yoga for the Ageless. Do we still get paid? Yes. Okay, then let's keep going. But I think that's, yeah, we're still getting paid. So let's just do this. Let's just run it out, run out the clock.
Who the hell,
but I think,
who the hell's putting the bill?
Yeah, exactly. Yeah, that's another question that we have still. But that's what the whole point though of the summary judgment is to, to put an end to this, and hopefully Judge Ludwig grants that summary judgment. Put all of us out of our misery.
With prejudice.
With prejudice.
Oh
yes.
my God.
Yes,
I'd hate to even think about it not being granted, because there's nothing else to present. And this case popped back up again. Oh my God. I probably would just say, nope, no, thank you.
Nope. We're done.
Yeah. Give me the highlights and I'm walking away.
Yeah.
Because
it'll just be, I'm sorry?
The birthday girl's here.
Oh, hi, Susan.
Susan.
Hey. Oh, good. Now we're not so duo-y, huh, Jack?
That's right. We got a team.
Yeah, we got a crew now.
If you're talking, Susan, we can't hear you yet.
Oh, can you hear me now?
Now we can hear you.
Hello.
I can sing it if you want.
Yes, I want.
Oh, she wants you to sing.
Okay, maybe later.
Okay.
Just kidding.
Thank you all.
Welcome.
All right, Rhonda, whenever you're ready.
Okay. Number 5, MAM accurately captures the gist of plaintiff's testimony about the key. Plaintiff's criticisms of MAM's coverage of his testimony regarding the discovery of the key in Avery's bedroom fail to identify any material falsity and amount to semantics. He complains that in showing his denial that he had planted evidence, MAM does not use his testimony. Quote, "That's ridiculous. No, I have not," end quote. But instead includes his testimony. Quote, "I have to say that this is the first time my integrity has ever been questioned, and no, I have not," end quote. He does not identify any material falsity, but merely claims this is, quote, "less forceful than the actual response," end quote. God. Ignoring that MAM shows him not just denying, but expressing deep personal affront. Plaintiff also criticizes MAM's compression of the testimony from Calumet Sergeant Tyson. But that criticism ultimately boils down to semantics between babysitting versus watching the officers to make sure they weren't alone on Avery's property. Yeah, semantics. That's what this whole freaking case is based on, semantics.
It is.
Many of plaintiff's criticisms are nothing more than I don't know how to say that word. Pedantry. He complains MAM does not include his testimony that he thought the key, quote, "was a very important piece of evidence," end quote, because it had a Toyota emblem. But MAM includes a close-up shot of the key itself with its Toyota emblem, and also makes clear that Ms. Halbach's car was a Toyota. In other instances, plaintiff argues that MAM, quote, "omitted 30 pages of his testimony," end quote, numerous transcript pages, and 20 lines of trial testimony. 20 lines of trial
Yeah,
testimony that Ma'am omitted.
Yep, he bitched about that. Go ahead.
Yeah. Ignoring that Ma'am necessarily had to condense all witness testimony, including his. Plaintiff repeats his complaint about Ma'am's coverage of his report writing, but ignores that the producer defendant's moving papers address this issue. And ultimately, whether he wrote one half page of reports or 2 short reports, the gist is the same. His report writing on the Avery case was minimal. Yes, it was, and that he cannot deny it, no matter how he wants to color it. Plaintiff also complains that Ma'am showed, but did not go into greater depth about, his speculation about how his moving furniture might have dislodged the key, or how he instructed Calumet Deputy Kucharski to photograph the key. But plaintiff does not, because he cannot, demonstrate any of his criticisms rise to the level of Ma'am presenting the substance of his testimony in a materially false manner to his detriment. Number 6. Plaintiff's complaints about his physical reactions in Ma'am are meritless. Plaintiff complains about Ma'am depicting slightly different reaction shots of him at trial, but he provides no evidence that they materially alter the gist of his testimony or are the result of bad faith. Nor does he dispute that the substituted footage is actual footage of him testifying at trial. He claims that any alterations are quote unquote obviously intended to make plaintiff look bad, nervous, or not credible. Demos provided detailed explanations regarding the unusable footage issues with the witness-facing camera for each of these instances and the need to substitute with mixed feed footage. The video files themselves reflect the footage issues with the witness-facing camera and available alternatives. And is that the
Camera A?
Camera A, okay. Any moments showing plaintiff not looking up or making eye contact are moments that actually occurred and were captured in mixed feed footage. Plaintiff admitted at his deposition he is an introvert and gets nervous testifying, and his former counsel described him and others as looking quote unquote defensive in depositions in Avery's civil suit. Without any material complaints, plaintiff resorts to falsehoods. He claims Ma'am includes a long pause during Strang's cross-examination of him, and in the Halbach trial, Strang moves right into the next question. There is virtually no pause. Plaintiff's own evidence shows that is false. There was a 7 or 8 second pause in both the raw footage and in Ma'am. Similarly, plaintiff criticizes Ma'am's use of footage he claims makes him appear to shift uncomfortably and engaging in knuckle cracking. But he later points to this same footage, complaining it was not used in another scene, and describes it as making him look more confident. Footnote 15. Plaintiff focuses on statements that are not Plaintiff focuses on statements that are not, quote, of and concerning, end quote, him. And he misrepresents the statements themselves to obscure that. Okay, so for example, in document 327 at 29, it references in Netflix and Manhart notes to baddies, villains, and mastermind of conspiracy who are identified, for example, former MTSO Sheriff Kasurik and former DA Vogel, but do not include plaintiff.
Well, there you go.
3. Plaintiff has not met his burden of proving actual malice. A. Plaintiff ignores the producer defendant's evidence, negating actual malice. Plaintiff's opposition ignores Riccardi's and Demos' detailed declarations in support of their MSJ. Motion for summary judgment, I think is what that is.
Yeah.
Those declarations comprehensively refuted plaintiff's actual malice allegations, explained why editing decisions were made, and in Demos' case, provided explanations that were tailored to particular pieces of raw footage for the relevant portions of MAM. Although it is plaintiff's burden to prove actual malice with clear and convincing evidence, the defendant's burden to disprove it. The producer defendant's detailed evidence negates actual malice. Far from knowingly or recklessly presenting plaintiff's testimony in a materially false manner, the producer defendants went to great effort to accurately capture its gist. Plaintiff's failure to substantively engage with the producer defendant's declarations is telling. He has no answer for them. Plaintiff does not dispute the facts that plaintiff does not dispute the facts from Avery's case files or present evidence of factual inaccuracy in those records, nor does he argue that it was unreasonable for the producer defendants to rely on copious government records to map out the story of MAM. Instead, he claims everything is hearsay. For example, claiming defendants' declarations hearsay, but compared to document 317, the plaintiff's own declaration, plaintiff misses the point. Much of this record is not being used for truth of the matters asserted, but rather to show one, active efforts to fact check and present a truthful story, disproving actual malice, for example, reviewing case files and reports, and hiring rights and clearance counsel to vet MAM to ensure it was not defamatory.
I think this is a continuation of
just
the
a
prior.
continuation of that sentence.
Mm-hmm.
Yeah. Okay. Statement by Avery attorney about unconscionable withholding of information by Kusurik and Vogel. Complaints about portrayal of Avery verdict. Statement about reliable narrators in a dig at Kratz. Complaints, re-alleged omissions, and addressing defects in plaintiff's arguments about alleged omissions in MAM.
Yeah, that's where we're talking about the baddies and the villains and all that shit and the prior footnote, page 12. Anyway, continue on.
Defamatory. Prior consistent statements to rebut allegations of misconduct, for example, emails about the unterminated feed. I've never read that word, but I've never heard this word before. Sorry. Plaintiff's party admissions. Or number 3, plaintiff's party admissions.
Before you start with B, any comments? Doc, Alice, anything from the chat? You guys want to comment before we start on this next section?
There's only like 4 pages left.
Yeah, nothing from me. It's just pretty standard. Nothing that stands out to me so far.
Right. Yeah, I've been trying to look at the chat, but I haven't seen anything that's really caught my eye. So, all right, let's. Okay. Yep. Let's move on.
Okay. B. Plaintiff cannot prove actual malice with clear and convincing evidence. 1. MAM's inclusion of Avery's and his defenders' viewpoints is not evidence of actual malice. The producer defendants' moving papers explained why, under governing law, MAM's inclusion of Avery's and his defenders' viewpoints is not grounds for actual malice. That case law includes most prominently Torgerson, and it cites a big old bunch of cases, all affirming summary judgment based on Time Inc. v. versus Pape. Plaintiff's opposition does not address or even mention these cases or numerous other cases cited by defendants. Under that governing law, Ma'am's inclusion of Avery's and his defender's viewpoint would not establish actual malice, even if that was all that Ma'am included. But Ma'am also includes plaintiff's denials of Avery's accusations, as well as others supporting plaintiff and opining that Avery is guilty. And discussing this, they were discussing efforts to get access to law enforcement and their efforts to reflect law enforcement viewpoints through statements made in legal proceedings, press conferences, and news reports.
You see that point there? Just hold a sec, just Rhonda. You see that point there? That's going to sink Colborn. That there is going to sink him, because Ma'am presented both sides of the argument.
That's right.
Ma'am did not present pro Stephen Avery. Ma'am presented both sides of the argument, and as just Rhonda just read out, they used multiple sources to present both sides of the argument. The judge is going to look at this and say, well, how could Ma'am possibly show any bias towards you, Mr. Colborn, if presented you denying the fact that you planted anything? If they had left all of that out, you could understand a form of bias. The fact that they presented it all in, and remember, guys, they even got the opinions of people on the street, right?
Yeah.
So
That's right.
Ma'am did not leave anything out. In actual fact, the more testimony of Colborn that they put in, the worse it looked for him. So in effect, Ma'am did him a favor. How
Huge
bizarre is that?
Huge
How
favor.
bizarre is that?
Yeah. But he's complaining whatever they did use and say was defamatory.
Yep.
And libel. Sorry, I'm repositioning here. Yeah. Yeah, that's a good point, Dr. Silkman. Okay. 2. Yeah, number 2. Plaintiff focuses on material irrelevant to the producer-defendant's for actual malice is a subjective inquiry focusing on specific defendant's knowledge, intentions, and scienter. I don't know what that word is either.
I'll look it up. Go ahead.
Okay, thank you. Lacking evidence of actual malice by the producer-defendants, plaintiff's opposition focuses on statements and opinions of others and then impermissibly tries to conflate them with those of the producer-defendants. Mary Manhart's emails and deposition testimony. Plaintiff's opposition acts as if Mary Manhart were still a defendant in this case, but plaintiff chose to drop Manhart when he filed his amended complaint. Nonetheless, plaintiff's opposition devotes many pages to Manhart and seeks to blur all distinctions between her and the producer-defendants. In so doing, plaintiff resorts to outright misrepresentations. He falsely describes Manhart as quote-unquote Chrome's editor or Ma'am's primary editor and tries to confuse her personal reactions and views with defendants' states of mind. Defendant Demos was the lead editor of Ma'am, and Manhart's deposition testimony shows the limits of Manhart's involvement with Ma'am. Manhart explained that by the time she joined the then already 10-year-old Ma'am project in 2015, quote, films that were episodes 1 through 4, I guess, were in very good shape. They were very solid, rough cuts, very solid, end quote. When asked about her consulting editor credit for episodes 5 to 9, which include the trial episodes that plaintiff's second amended complaint focuses on, Manhart explained, quote, those were really Moira's, and I did almost nothing on them except watch them and give notes, which is what a consulting editor does, end quote. The only episode for which Manhart received an editor credit was episode 10, which takes place after Avery's and Dassey's convictions and sentencing and is not a focus of plaintiff's claims. Moreover, Manhart always worked under Demos and Riccardi's instruction and supervision, and she stopped working on MAM 3 months before the series was even delivered to Netflix and before final editorial choices have been made for any episodes. Plaintiff cannot rely on deceptive phraseology such as, quote, "Mam's primary editor," end quote, and quote unquote Chrome's editor or quote unquote Chrome's creative to pass off Manhart's opinions as those of the producer defendants.
Hold on just a second,
Moreover,
Rhonda. Hold on a second. I found the legal definition for that word slander.
oh, okay.
It's pretty brief, and I posted a link in the Discord chat. I'll put it in YouTube as well. It says intent or knowledge of wrongdoing when a person has knowledge of the wrongness of an act or event prior to committing it. It's kind of a wordy thing, but yeah. I'll put the link in YouTube as well.
Okay. Yeah, thank you.
Yep.
Yeah, I like to have a basic idea of what the words I'm reading mean. So, okay. Moreover, plaintiff's accusations of bias against Manhart do not withstand scrutiny. For example, plaintiff imputes malevolence to Manhart's use of the term Frankenbite. Manhart clarifies that by Frankenbite, she's simply describing taking a word from one place and adding it to another to provide clarity. Plaintiff's counsel pointed out an instance in a MAM episode. Quote, "Teresa Halbach is substituted for the word she," end quote. Adding such clarity is not actual malice, nor is it actual malice to have human reactions to subjects in a story. Plaintiff reads subtext into Manhart's excitement to meet Stephen Glenn after MAM aired, yet plaintiff himself describes Glenn as an amiable there's another word I don't know how to say. Raconteur. Griefback and Glenn exchanging warm emails. Okay.
Another
Footnote 16. Yeah. Manhart, footnote 16. Manhart is far from the only witness in this case to trade a snide message about Ken Kratz, the prosecutor who resigned after being exposed for sexually harassing a domestic violence victim. Plaintiff did too with Brenda Schuler.
Oh, well, all righty then.
In your face, Colborn.
If the shoe fits, right? So you can see here that, what this is really embarrassing when you think about it, right? So Colborn and whoever's representing him is throwing a lot of mud and accusations, and yet his own team have done the same thing.
Yep.
His own team. And how embarrassing for Netflix to now quote all the examples where Colborn and his team transgressed as well. We can blame Kratz.
Yeah. That's just an in your face moment right there. Just,
yeah.
If you're gonna
What's the truth?
You're accusing us of the same thing that you did, just on the other side.
And buried it.
And yeah. Yep.
Because a lot of the stuff we didn't have a clue about until 7 months ago, May, I think it was.
Yeah.
And I think, guys, that's why Brenda Schuler doesn't want those 4,000 emails to be released, because I'm sure they're going to be potentially very embarrassing.
Inflammatory. I could almost bet on it.
Probably would definitely sink this case if it's not already sunk. But Oh gosh.
Well, yeah,
Wish we had
because
those. Wish we could see those.
well, yeah, because simply of the connection of attorney-client privilege stuff being discussed openly with a third party, to me is that's sacrosanct. However you say that word or that phrase between a lawyer and a client. You don't include a third person. You don't, because then now you've absolutely said, okay, well, it's okay for other people to read this stuff between my attorney and the client, and it just destroys the case anyway.
Yeah. Yeah. It just makes him look even more ridiculous, if that's even possible. Okay. Excuse me. Netflix executives' emails and deposition testimony. Plaintiff also focuses on notes and deposition testimony from certain Netflix executives that, at most, might speak to Netflix's state of mind, although, even there, they do not remotely show actual malice by Netflix. They merely reflect that those Netflix executives had personal opinions about particular aspects of MAM and the underlying events. Just like any MAM viewer, the Netflix executives inevitably interpreted events through their own personal perspectives because they're human. At times, they found certain allegations by Avery's attorneys against plaintiff to be weak or thin, and at other times, they found Avery's attorneys questioning of plaintiff to be a cliffhanger and strong end to an episode, as they felt plaintiff had been caught in a lie. Regardless of Netflix's executives' statements and opinions are not evidence of the producer defendant's supposed actual malice. And footnote 17. The producer defendants had creative control over MAM and took Netflix executives' notes as suggestions, implementing those they agreed with, but not those they did not. Regardless of whether Netflix's Del Deo mistakenly believed Avery's attorneys were suggesting law enforcement killed Miss Halbach, MAM includes statements by Avery's attorneys at trial, making it clear they were not accusing law enforcement of murder, but rather arguing that they planted evidence because they thought Avery was guilty. Contrary to plaintiff's claims, MAM did not, quote, set up Colborn as a potential cop to plant, end quote, evidence, nor did defendants create a narrative that plaintiff was always a suspect in alleged tampering with evidence. Rather, Judge Willis's order explicitly permitted Avery to accuse plaintiff and Link, and only them, of planting evidence, and Avery's attorneys subsequently did so. Plaintiff does not dispute this. Number 3. Plaintiff fails to present clear and convincing evidence that the producer defendants made any defamatory statements with actual malice. Plaintiff's opposition devotes scarcely a Plaintiff's opposition devotes scarcely a page to the producer defendant's supposed actual malice. Footnote 18. Footnote 18. Plaintiff adds a few pages of boilerplate case law on actual malice, but he fails to connect it to the evidence or issues in this case, just to make it look like he knows something, which makes his attorneys look even more in
Bad lawyering.
inept, in my opinion. Yeah, very much so. Portions of that page are nothing but outright misrepresentations, such as the falsehood that, quote, Chrome does not and cannot deny that it was intimately involved in the editing that falsely portrayed Mr. Colborn's testimony and even his appearance while testifying, end quote. Chrome denies that explicitly and unequivocally, and disproved it in its moving papers. In the handful of instances in which plaintiff moves beyond misrepresentations and focuses on documents and deposition testimony of Riccardi and Demos, his argument falls flat. He cites an email regarding the promotional trailer for MAM, which is not the basis for any claims in the second amended complaint, in which Demos refers to a quote unquote squirmy shot of plaintiff on the witness stand, but plaintiff admits he is an introvert who gets nervous testifying. And plaintiff's former counsel described watching Avery's civil suit deposition testimony of, quote, the officers who were most directly accused of wrongdoing, either in the first Avery case or in the second, end quote, which includes Colborn, as, quote unquote, watching them squirm, and observed that Ma'am's portrayal of their testimony, quote, was not simply a case of only selective editing to make them look bad, end quote. Footnote 19. Moreover, Demos explained the reason for suggesting the squirmy shot in the trailer, or alternatively a shot of Peterson, was not to make plaintiff look bad. Also, plaintiff,
The bottom of the next page.
I was going to say that's really strange. Thank you. Also, plaintiff claims Ma'am includes footage of plaintiff looking deflated at the end of cross-examination, even putting aside his obvious subjective spin in that characterization. Demos explained that the substitution of footage was done there because of a lack of usable footage, and that she believed it did not present him in a materially different way. He thinks it did. Okay. Okay. I was trying to figure out where we were going now. Okay. Elsewhere, plaintiff focuses on an email by Riccardi mentioning that Avery was Ma'am's protagonist, and emails from others referring to the prosecution and law enforcement as antagonists. These notes simply reflect that Avery is the main character whose story is the center of Ma'am, and that law enforcement and prosecutors were his opponents in the adversarial legal proceedings documented by Ma'am. Similarly, plaintiff points to notes from Manhart and Demos regarding episode 3, in which they are discussing the audience, quote unquote, regaining faith in Avery and quote unquote, feeling guilty for believing certain allegations about him in a particular point in the series. But plaintiff ignores that those same notes also discuss how, at a different point, the audience could feel duped by Stephen Avery and even angry about that. And, excuse me, the story of Stephen Avery contains many twists and turns, allegations, and counter allegations, and the notes reflect that. And footnote 20. Plaintiff also ignores that particular notes provide feedback with respect to specific portions of Ma'am. For example, the note about regaining faith and feeling guilty concerns a particular point in episode 3. The verdict against Avery does not even occur until episode 8, although plaintiff's opposition frequently ignores this chronology. Plaintiff complains about Ma'am's inclusion of graphics and juxtapositions of his image, but ignores that a central part of Avery's defense at trial was that plaintiff and other Manitowoc officers planted evidence. While he claims defendants intended to villainize Mr. Colborn as part of a law enforcement conspiracy through Ma'am, he fails to cite any evidence in support of that claim. Instead, he impermissibly conflates what certain Ma'am subjects say with what defendants supposedly say. But Ma'am makes it clear to viewers that it is Avery and his defenders accusing plaintiff of planting. That allows viewers to decide whether to credit those accusations or not based on their That allows viewers to decide whether to credit those accusations or not based on their source. Full or pretty full publication of the grounds for doubting a source tends to rebut a claim of malice, not to establish one. Plaintiff also ignores portions of Ma'am critical of Avery and pushing back against Avery's accusations against plaintiff, including Avery's brother opining that Stephen probably murdered Teresa Halbach and his sister is telling Stephen, "You can rot in hell." And footnote 21. Plaintiff's reliance on Hatfield v. New York Times is misplaced. Hatfield addressed defamatory meaning, not falsity, at the 12b6 stage. Even in that context, it dealt with the defendants attributing criminal allegations against plaintiff, quote unquote, to unnamed sources. Mann makes clear that Avery and his defenders accused plaintiff. Was that okay? Was that 21 I just read? Yes, sorry.
Yes, it was.
Fundamentally, plaintiff's premise that if defendants held certain viewpoints about the subject matter of Mann, that would constitute actual malice, is not just lacking in evidence, but legally flawed. Okay, let's do footnote 22. In moments of candor, plaintiff has admitted that his argument that having a viewpoint equals actual malice lacks merit. For example, he states that, quote, in the context of documentaries, which often accompanies an assumption by viewers that while the documentary may advocate a particular point of view, end quote, emphasis added, and at his deposition, plaintiff made similar admissions. I'm looking for 22.
This is right above. It's the last paragraph. Last paragraph where you start plaintiff's arguments.
Okay. Oh, okay. I see it. Plaintiff's arguments about libel by implication or innuendo fail. First, his second amended complaint does not plead libel by implication or innuendo, and he cannot amend his second amended claim sub rosa via his opposition brief. Second, even if he had pleaded such a claim, if the plaintiff is claiming defamation by innuendo, in addition to proving actual malice, quote, he must also show with clear and convincing evidence that the defendants intended or knew of the implications that the plaintiff is attempting to draw from the allegedly defamatory material. Plaintiff does not attempt to prove this or even acknowledge it is required, and he ignores Sains and Woods despite defendants' repeated citation to them. Finally, as part of his, quote, throw everything at the wall and hope something sticks, end quote, approach, plaintiff falsely accuses the producer defendants of, quote unquote, missing documents and videos. In response to plaintiff's 7 cents of RFPs, producer defendants produced over 35,000 pages of documents, plus more than 15 hours of raw footage of plaintiff's trial testimony. Demos and Riccardi spent more than 250 hours combined in connection with responding to plaintiff's requests, and their counsel spent many hundreds of additional hours. The producer defendants produced all responsive documents in their possession consistent with what they agreed to produce. Indeed, plaintiffs' complaints often ignore the scope of the producer defendants' agreements to produce, which in some cases were limited based on relevancy and proportionality in light of the incredibly overboard requests served by plaintiffs. Document 316, attachment 2 is a letter responding to erroneous contentions regarding discovery. The producer defendants also clarified what materials they no longer possessed. Tellingly, plaintiff never brought any motion to compel. 4. Plaintiff's emotional distress claims also fails. Plaintiff's opposition does not dispute that if his defamation claim fails, his IIED claim necessarily fails too. Even if his defamation claim were not dismissed, summary judgment of his IIED claim would still be proper. Well, that was the end.
Wow. And just boom.
Yeah, they
This
just did it. It was like,
and
oh wait, that's the end.
and this is this was actually done by Vic. Looks to me like he's learned some
Yeah, it
lessons from
was.
Lita. I
From
think
Lita,
Lita.
huh? Yeah,
I think
yeah,
she's taught him well because I mean, to me, this
yeah,
is very well written. And
yeah. I think so.
before I get into, I am going to play this Colborn call to dispatch. But any comments before I get into that and my commentary on that or on the document? Doc, Alice, you guys got anything you want to add?
The only comment I want to put from having that read out is the high degree of paranoia, absolute paranoia from Andrew Colborn and his team. And what I really loved about this response by Vic, they were absolutely meticulous in breaking down all the claims that Colborn had to say, hey, look, we presented a balanced view. We have no control of how you act in court. Remember, it was Stephen's attorney and Stephen's as well who said, I believe that these officers planted evidence against me, right? So hence, the way they presented the trial material was, okay, Strang and Buting were questioning the relevant officers. Okay, did you plant this evidence? Were you there? Were you looking at this number plate? It sure looks like you were. So in other words, what Netflix showed, in my opinion, was totally relevant, unbiased, and was balanced, right? And the judge is going to look at this and say, well, Mr. Colborn, if you had seen all 10 episodes, you would have realized that the producers gave as much time to your side as they did to Stephen. And they also presented negative comments about Stephen by his own family, right? So Colborn can't claim to say, hey, this whole show was biased towards me to make me look bad, when I believe it really was about, because remember, you've got two sides in a court. You've got the defendant, you've got the state, and you've got the appropriate questioning. I thought Mam captured that beautifully. To me, this highlights Colborn's total paranoia. Somebody put him up to this. Somebody put him up to this. I wonder if it was Kratz.
Yeah, and it, they in many ways they leave out this adversarial process that is part of our justice system, and that seems to get lost. Anyone else? Susan, you have any commentary? I know it's your birthday and all, but still, anything that you want to add to this particular document here?
One thing I noticed is how they point out how he just kind of ignores a lot of their points.
Yes.
And case law and stuff like that. I think they have a winning case. I can't imagine them not.
Oh yeah, getting summary judgment. It's going to be hard to believe if the judge rules otherwise. I think that well, for myself and reading through all this, this is a really good point. When we got to the end, at some point, I was going to play this call anyway, but this really points it out really well, because they talk about it not at too much of a length, but they did talk about this call, this plate call. And I want to point out to everyone the irony of how, well, number one, think back in real time to 2006 and how many requests that Buting and Strang had put into Kratz to get these calls. There was one in July, and they still hadn't gotten anything until this hearing in August. It was like August 9th or 10th, I think. And Remaker was on the stand. And he openly admits, hey, I listened to some calls in preparation for this testimony. Oh, you did? Well, then that led to some other, shit going on at trial. And they finally end up with like 30 calls out of thousands. 30 calls that they got produced and handed over. So I think the irony is, one of the points in Colborn suit that they're hiding shit. They still got more they haven't given us. Really? So anyway, I want to play this call. It's a little over a minute. It's not very long. So let me get this pulled over here.
Just to say, Jack, Becca's joined us in chat. Hiya, Becca, and
Hey.
happy birthday. Hope you've had a nice day.
I didn't see Becca.
Yep. Happy birthday to you. I won't sing it though.
Happy birthday, Becca.
Anyway, this call is denoted in the narrative log of incident log. I think it's 8844. I think I'm saying that right. Anyway, we've got it, and this call comes in at 9:22 to MTSO. If you're here in Discord, you're gonna have to unmute to hear the call. So let's play this. Like I said, it's just a little over a minute. I want to play it.
Manitowoc County Sheriff's Department, this is Lynn.
Lynn,
Hi, Andy.
can you run Sam William Henry 582? See if he comes back to that.
Sam William Henry 582. I need telephone, please. Alrighty. Do you speak any Spanish there, Andy? I'm just going to call him the top of the list. It's mine. On call, didn't call me back. And when I get in trouble, Andy, I get in trouble. You know? What am I supposed to do?
Yeah.
My favorite one is in the city of Manitowoc. Yes. Okay, it shows that she's a missing person, and it lists to Teresa Hallback.
Okay.
Okay, that's what you're looking for, Andy?
99 Toyota.
Yep.
Okay, thank you.
You're so welcome. Bye-bye.
Play that one more time.
It lists to Teresa Hallback.
Okay.
Okay, that's what you're looking for, Andy?
99 Toyota.
Yep.
Okay, thank you.
You're so welcome. Bye-bye.
So there you go. You remember that was kind of a deal at trial at court. He claims that she said it, and in fact, he did.
Yeah. Yeah, and then Strang had to replay it for him.
That's
well,
right.
Let's just see.
Yeah, well, yeah. Let's find out here. So the reason, that's kind of the reason I did it again anyway. So I just wanted to play that, in conjunction with everything that we've been listening to, or not listening to, but reading, listening to Rhonda and others read through this stuff. It's just so ridiculous to me. I got to tell you.
Yeah, so funny, Jack, because when me and Disco went to see Making a Murderer the musical, that was one of the bits that they were taking the piss out, and they had that on the screen, on the stage, and it's him saying, Sam William Henry 992, and the yep at the end, and I was like, oh, fucking brilliant. So it's definitely relevant, you know what I mean? Definitely. Because everybody says about that. Well, he was calling in the place and he was standing right in fucking front of you.
Yeah.
Yeah, I wish we could see that. I'm pulling up right quick here. This is Cherie had put a link in our Discord chat about the Financial Fiduciaries LLC and Thomas Bernstein versus Gannett, and this is the case that they've quoted numerous, and it looks like it was argued February 9th, 2022, and decided on August 20th. And we're not going to read it right now, but we've got it, and maybe some night we can take a look at this, maybe get a summary and talk about it a little bit, because they do reference it quite a bit, not just this document we just read, but other ones as well prior to this. So thank you so much, Cherie, for doing that.
Yeah.
She's so handy. She's so good. She's fast.
Yeah. It's fast.
This next one is a 24-page document, and this is a response from Colborn. And Doc, if you're up for it, would you like to read for a bit? Are you up for that?
Yep, I can read a little bit. If I've got to go, I'll just go. I'll let you know.
Yeah.
Yeah.
Cool.
Yep. Well, the documents. I don't know if you got it downloaded, but there's a download link in the.
Yeah, I've got it.
Okay. Well, you just start whenever you're ready. This is document 357, and this is the last one we have so far. So.
Okay. Is that the one that commences with producer, defendant, supplemental proposed finding of fact?
That's correct. No, it's the plaintiff Andrew L. Colborn's response to produce. Yeah. Yes, that's right.
Yep. So I'll start at point number 3.
Yep.
Okay. 3. Producer, defendant, supplemental proposed finding of fact. A. Working with Netflix. 1. Netflix creative executive Lisa Nishimura has attested that, quote, "From the moment I met Laura and Moira, they impressed me. They had conducted exhaustive research into Stephen Avery's story and had full command of the facts. They struck me as fastidious and meticulous and devoted to telling Avery's compelling story with accuracy and respect for all involved. As I worked with the filmmakers to bring Ma'am to fruition, my initial impression of them was confirmed. I trusted Laura and Moira. They never gave those of us at Netflix reason to doubt them or their work, and we relied on them to get the facts right." Docket 275, Declaration of Lisa Nishimura. You want me to read the responses as well, Jack?
Please.
Response 1. Plaintiff objects to the relevance of the self-serving narrative statement as devoid of any probative value. 2. At his deposition in this case, Netflix creative executive Adam Del Dio testified to the following, quote, "I was very impressed at how they wanted to capture, accurate, factual events, really follow the story from the Stephen Avery perspective, and also from the perspective of the police officers involved in the case, Manitowoc, and let the subjects capture in an objective way what was happening." Docket 279, Declaration of Lita Walker. Deposition transcript of Adam Del Dio. Response 2. Plaintiff objects to the relevance of the self-serving narrative statement as devoid of any probative value. Point number 3. Throughout post-production, Netflix creative executives provided notes, but those were suggestions, not demands. The filmmakers chose how to implement notes and retain creative control. Docket 290, Declaration of Laura Riccardi, and then there's a whole heap of transcript depositions. Response 3. Plaintiff disputes this proposed fact. Defendants testified uniformly that Netflix approved the series and it had the right to do so. The Netflix representatives of the creative team that participated in the production of Ma'am reviewed and approved the final versions of all episodes of Ma'am prior to it being published. Proposed undisputed fact 59, Barker Declaration, X3, Nishimura transcript, then there's a whole lot of other things. Moreover, the series notes repeatedly show Chrome providing revised version after receiving Netflix notes, with Netflix approving them, as explained in plaintiff's prior proposed finding of facts, see docket 325, cap FF number 2. At these calls, Netflix provided its comments and direction for the series, ID. As just one example, Netflix approved a revised version of episode 5 with the comment that, quote, setting up Colborn as a potential cop to plant, end quote, the SUV, quote, works really well now. Then there's a docket and NFX call number. Point number 4. Netflix deferred to the filmmakers on presenting an accurate story, and Netflix did not suggest that the filmmakers sacrifice accuracy in order to speed up the pace of a scene or make a scene more impactful. And then there's a couple of examples of where the quotes came from. Suggesting holding one scene longer if possible, but acknowledging, quote, we know this is court footage that may not exist, end quote. Response 4. Plaintiff disputes this proposed fact. Defendants testified uniformly that Netflix approved the series and it had the right to do so. The Netflix representatives of the creative team that participated in the production of MAM reviewed and approved the final versions of all episodes of MAM prior to it being published. Proposed undisputed fact 59, Barker Declaration X3, Nishimura transcript at pages 170 to 171, and then there's a few other license agreement excerpts. Moreover, the series notes repeatedly show Chrome providing revised versions after receiving Netflix notes, with Netflix approving them. As explained in plaintiff's prior proposed finding of fact, see docket number 325, cap FF number 2. At these calls, Netflix provided its comments and direction for the series, ID. As just one example, Netflix approved a revised version of episode 5 with the comment that, quote, setting up Colborn as a potential cop to plant, the SUV, quote, works really well now, end quote. Netflix also repeatedly suggested that Chrome cut for space and that it avoid lengthy courtroom scenes. And then there's a couple of docket numbers. Point number 5. Nishimura stated in her declaration that edits regarding pacing were intended to, quote, engage the viewer, end quote, and help the viewer digest the most salient points of a long and sprawling account. Nishimura Declaration. Response 5. Plaintiff objects to the declaration as containing self-serving testimony that appeared to contradict the claims by Nishimura at her deposition, and that she did not remember much about the series except what she read in notes and exhibits provided to her. Plaintiff further objects to the relevance of the statement and dispute that it proves that defendants did not act with actual malice or any other fact relevant to this case. Moreover, the Netflix communications show that Netflix was pushing for shorter episodes. Then there's Baker Declaration. Even if, quote, engaging the viewer, end quote, was the goal, this is not an excuse to make edits in a manner that did not fairly represent the subject.
The thing about it, you think about what they're trying to get the judge to do, and potentially a jury. Even that call that I just played a minute ago, I probably, if somehow made it through court and he won, I probably wouldn't take a risk of playing it for fear of being sued.
Correct. Yep. Correct. Crazy stuff. Do you want me to continue, Jack 61?
Please continue.
6. Del Dio has attested that Netflix employees suggested that episodes should end on a cliffhanger in order to keep viewers engaged, so they watch the next episode. See Del Dio declaration, then there's a whole lot of additions. Response 6. Plaintiff objects to the relevance of the statement and disputes that it proves that defendants did not act with actual malice or any other fact relevant to this case. Point number 7. Nishimura has attested that, quote, in the notes, we recommended that the filmmakers, quote, foreshadow, end quote, future plot points in early episodes in order to keep viewers engaged so they would watch coming episodes and benefit from receiving a complete account. This is not an unusual suggestion. We wanted viewers to watch all 10 episodes of the series to get the full story man was intended to capture, end quote. Nishimura declaration. Response 7. Plaintiff objects to the relevance of the statement and disputes that it proves that defendants did not act with actual malice or any other fact relevant to this case, and objects to the extent that Nishimura is being proffered as an undisclosed expert witness.
Oh my God.
Plaintiff further objects to the declaration as containing self-serving testimony that appeared to contradict the claims by Nishimura at her deposition that she did not remember much about the series except what she read in notes and exhibits provided to her. I'm telling you, this is shocking. Shocking, guys. Shocking.
There's nowhere that I can recall of Lita Walker or Kevin Bick presenting Nishimura as an expert witness or expert anything. What the fuck?
But guys, they're even complaining that the filmmakers wanted it made such that you wanted to watch the next episode. Tell me one documentary that says at the end, oh, this is a 10-part series. Please don't watch the rest. They're all boring as shit.
Right.
What the hell are these guys complaining about? What the hell?
This is unbelievable.
So is convicting murder just one episode?
Well,
it's convicting murder just one episode.
I don't think so. I think it's a multi-episode part, but surely they're going to have a thing at the end that says, "Don't watch any more of it. We're done. Thanks." But there's several more episodes, but don't bother to watch them.
Don't bother to watch them. Yep, the judge must be scratching his head at this stage, especially if the judge has actually watched the series and watched other documentaries on streaming platforms. This is the same template that everyone uses.
That's right.
Yeah.
That's right.
It's the purpose. It's the purpose. That's the purpose of releasing serialized documentaries or podcasts, or that's the whole purpose. It's just, this is insanity.
Correct. Point number 8. Creative executives sometimes use Alice, colorful language and terms of art when providing notes to filmmakers. See Del Dio. Response 8. Plaintiff objects to the relevance of the statement and dispute that it proves that defendants did not act with actual malice or any other fact relevant to this case and objects to the extent that Del Dio is being proffered as an undisclosed expert witness. Oh boy. Oh boy. Point number 9. Sorry, just Rhonda, did you have a comment?
No, I'm just listening. I just said the word undisclosed. Undisclosed. Now they're calling them all liars.
Do you have a lot of eye roll? I can feel an eye roll from, your western part of the U.S. and Scotland and other places of the world. Anyway.
I'm waiting for Alice to explode. Point number 9. Netflix creative executives repeatedly suggested changes to the series of music, including the, quote, lulling guitar, unquote, and, quote, prod rock type guitar music, end quote, but their suggestions were not implemented, and those themes remain an integral part of the series' musical score. Then there's various declarations, and it shows where the guitar is used in various parts of MAM. Response 9. Plaintiff disputes this statement as at numerous points during the series, ominous, foreboding music is played, especially when law enforcement representatives are on the screen. With respect to plaintiff in particular, his testimony is punctuated by ominous, pounding tones, and at some points with spooky chime music. Okay, then there's various dockets. Netflix encouraged Chrome to look for opportunities in MAM to include music that would help identify the, quote, baddies, end quote, i.e. law enforcement representatives, and to convey a, quote, bad guy theme, end quote, or, quote, villain theme, end quote, when they appeared on screen. It makes sense that Chrome would have worked with Netflix to incorporate the, quote, bad guy, end quote, and, quote, villain, quote, end quote, themes that Netflix wanted, because defendants testified uniformly that Netflix approved the series, and it had the right to do so. The Netflix representatives of the creative team that participated in the production of MAM reviewed and approved the final versions of all episodes of MAM prior to it being published. Just Rhonda, did you have a comment?
No.
Okay.
You must. I think he's echoing off you, Rhonda.
Okay. Proposed undisputed fact 59, Barker Declaration 3, Nishimura transcript at various pages. Moreover, the series notes repeatedly show Chrome providing revised versions after reviewing or receiving Netflix notes, with Netflix approving them as explained in plaintiff's prior proposed finding of fact. Docket 325, Cap FF number 2. At these calls, Netflix provided its comments and direction for the series. As just one example, Netflix approved a revised version of episode 5 with the comment that, quote, setting up Colborn as the potential cop to plant, end quote, the SUV, quote, works really well now, end quote.
I just want to insert right here, Doc, because they put so much effort into this bad guy music and bad guy theme. I'm going to tell you right now, I don't remember anything like that from Making a Murder, and I watched it a few times. The only music that really comes to mind for me is the opening theme where they're going through giving the credits and so forth. That's really all I remember as far as music. It's not like Jaws, when, the great white bucking 90-foot shark would come up, dun, dun, and you hear that
Correct.
music. I think Alice pointed that out very well a couple of times. It's such bullshit, absolute bullshit.
It's actually questioning the artistic integrity of the series.
Sure.
It's getting that petty now that apparently even the music offended Colborn. Everything offended Colborn. And so now, are you trying to tell me that now artists all over the world have to be cautious and careful what type of music they include in an episode? And really, when you think about it, if you were offended by watching Ma'am, you know what you do? You press the stop button on the remote control and cease to watch.
That's right. Flip over to another channel or another documentary or whatever. Just don't watch it.
Correct. Point number 10. At Netflix's suggestion, Riccardi and Demos integrated graphical elements to enhance the clarity and factual accuracy of the series, especially because Avery's prosecution for Horbuck's murder involved a large number of facts, events, dates, locations, and individuals, including numerous MTSO officers to keep track of. Then there's a whole lot of listing of where it came from. Response 10. Plaintiff disputes the characterization of Netflix's direction as a mere, quote, suggestion, end quote. Plaintiff disputes this proposed fact. Defendants testified uniformly that Netflix approved the series and it had the right to do so. The Netflix representatives of the creative team that participated in the production of Ma'am reviewed and approved the final version of all episodes of Ma'am prior to it being published. Proposed Undisputed Fact 59, Barker Declaration 3, Nishimura transcript at specific pages. Moreover, the series notes repeatedly show Chrome providing revised versions after receiving Netflix notes, with Netflix approving them as explained in plaintiff's prior proposed finding of facts. Docket number 325, Cap FF number 2. Any comments on that one?
Well, to me, it goes into the more ridiculous, because they're creating, they had an idea, the filmmakers had an idea for a documentary. They presented it to, I'm sure, more than just Netflix, but Netflix had liked it, said, hey, look, we're going to help you out financially, because they were doing this out of pocket. We'll help you financially. We'll hook you up with some graphics, some music, make this something really presentable to the public. And they're sending these snippets or scenes, whatever, back, after they've done some revisions. Maybe they've listened to them, maybe they didn't. It was still their vision of what they wanted to present. It didn't matter what Netflix may or may not have suggested.
Correct. And at the end of the day, guys, you don't make a documentary and set it out to fail. Correct?
Absolutely
you try
not.
To do the very best. So it's a form of entertainment that you understand. You're enlightened by the information that you've just seen, and you can make up your own mind. You don't set out a documentary to say to viewers, don't bother, this is all crap. Of course you want it to be successful.
That's right. That's the goal. It's a for-profit company. And I'm sure that, I don't know that in the forefront that this idea that they had to make this documentary was they just saw me a big cash register. I don't think that. I think they wanted to tell a story, and it polarized. It was so polarizing that this could happen in a small town in America. It had never been presented in quite this way before. And I think there's some intense jealousy on some people that, we've talked about, but really not at the forefront here. But this is another underlying theme here, because they were given awards. It was extremely popular. So I think there's some jealousy going on too.
Crazy. And of course, at the end of the day, this is going to put the spotlight squarely on convicting a murderer.
Oh,
right?
yeah. Oh,
Squarely on them. And I'll tell you what, if they transgress in any manner, it's going to get really ugly really quick.
yeah. It's going to bring one of your you used to work with I don't know what you call it, but one of those a microscope or whatever. That's what they're going to be under and presenting their version of facts.
Correct. Okay, point number 11. Del Dio unequivocally denied that he believes Mam to be asserting that Colborn planted evidence to frame Avery. Walker Declaration number 14, Del Dio Deposition. Response 11. Plaintiff objects to the testimony as it represents merely defendant's attempt to characterize Mam. The series is in the record and is the best evidence of what is in it. Docket 121 through 12010. Moreover, because numerous viewers did so interpret Man, and anyone who views it can see it does so assert, Del Dio's testimony is at odds with the plain reading of Mam. So his testimony is not credible on its face. It is also inconsistent with Netflix creative team notes, including Netflix's approval of a revised version of episode 5 with the comment that, quote, setting up Colborn as a potential cop to plant the SUV, quote, works really well now, end quote. Docket 331, page 39. NFX Col 278, and with an email exchange between Del Dio and Ben Kotner of Netflix, in which Del Dio noted that it appeared that Jerome Buting's comments in the series were accusing law enforcement officers of not just planting evidence, but murder. Docket 331, NFX Col 29495.
Wow.
Point number 12. Both Del Dio and Nishimura likewise have averred that Netflix did not intend for Mam to convey that Colborn in fact planted evidence, and that it never occurred to them that any reasonable viewer would understand either the series or Netflix to be reaching a conclusion about Colborn's culpability. See Nishimura, Declaration 18, Del Dio, Declaration 10, Response 12. Plaintiff objects to the testimony as it represents merely defendant's attempt to characterize Mam. The series is in the record and is the best evidence of what is in it. Docket 121 through 12010. Moreover, because numerous viewers did so interpret Mam, and anyone who views it can see that it does so assert, Del Dio's and Nishimura's testimony is at odds with a plain reading of Mam. So their testimony is not credible on its face. It is also inconsistent with Netflix creative team notes, including Netflix's approval of a revised version of episode 5 with a comment that, quote, setting up Colborn as a potential cop to plant the SUV, quote, works really well now, end quote. Docket 331, page 39, NFX Col 278. And with an email exchange between Del Dio and Ben Kotner of Netflix, in which Del Dio noted that it appeared that Jerome Buting's comments in the series were accusing law enforcement officers of not just planting evidence, but murder. Docket 331.
I never got that from Buting, and they're picking on one specific thing, and if that's all they got, Damn.
Correct. Because they went to great lengths during the trial, Buting and Strang, to say, we're not accusing the cops of murdering anybody.
That's right.
It was Kratz. It was Kratz.
It was Kratz.
Correct. Jack 61, I'll read one more. And we let somebody else read.
Absolutely.
Okay. 13.13. The filmmakers purposely did not present voice-over narration or a conclusion at the end of the series regarding whether Avery and or Dassey were guilty, leaving viewers with open questions. Riccardi, Declaration 47-48, Demos, Declaration 48-49. Response 13. Plaintiff disputes that the defendant's self-serving statements regarding their intent are sufficient to overcome the exhaustive summaries of actual malice that plaintiff summarized in his response to defendant's proposed findings of fact. Docket 326 at response PFOF number 126 to 141, docket 3261 and 3262. Moreover,
Exhaustive. What a perfect word for it.
Yeah.
Exhausted me.
No doubt.
We're all. Moreover, regardless of how Avery is or is not portrayed, the series can be and was fairly understood as accusing law enforcement officers of planting evidence. Docket 130-1. Oh boy. So what are they expecting the filmmakers to say? See, guys, Stephen and Brendan, they were found guilty. The law enforcement officers, they didn't plan anything. Sorry, guys, to disappoint. We won't be coming back for season 2. Is that what they wanted them to say?
It's like they pointed out. Somebody pointed out. I don't remember. I think it was in Vic's last filing. He pointed out that it wasn't C-SPAN. It's a documentary. They told a story as best as they could tell it and compacted a huge amount of information.
Yes, they did. They did.
All right. Okay. I'll read a few of these and then I'll probably hand it off. So I'm going to start with 14. The filmmakers do not know whether plaintiff or others in law enforcement planted evidence against Avery. They intended to convey the ambiguity and uncertainty they feel in the series and deliberately raise questions without telling viewers what to think. That's from the Riccardi Declaration and the Demos Declarations, their respective. Response 14. Plaintiff disputes that defendants' self-serving statements regarding their intent are sufficient to overcome the exhaustive, yes, we're all exhausted, summaries of actual malice that plaintiff summarized in his response to the defendant's proposed finding of fact, docket 226, in responses to the PFOF, and it gives the numbers there. Moreover, regardless of how Avery is or is not portrayed, the series can be and was fairly understood as accusing law enforcement officers of planting evidence. Docket 130-1. B. Differing viewpoints in and about Ma'am. 15. Plaintiff has never watched Ma'am in its entirety and watched only snippets totaling less than 30 minutes before bringing this lawsuit. He has since watched no more than an additional 30 to 45 minutes. That's from docket 278, Statement of Stipulated Facts. And the Declaration of Kevin. Response. Plaintiff does not dispute this proposed fact, but objects to its relevance. Wow, okay, that's short and sweet. Number 16. The series depicts differing reactions to Stephen Avery in the local community, with some who believed his framing defense, some who believed he was guilty, and some whose views were shown in changing over time. See example, Ma'am, episode 3, and it gives the time frames there. bar patrons playing pool with Stephen Avery's brother, Chuck Avery, expressing their belief in the framing theory. Then, ma'am, episode 3, then at 29, gives the time frame. Local news segment after the March 2nd, 2006 press conference, with 2 local residents interviewed at a bar expressing the belief that Dassey and Avery killed Teresa Halbach, and 1 local resident interviewed in the street whose mind was changed towards guilt. See, ma'am, episode 3, and it gives the time frame identifying on screen Chuck Avery, Stephen's brother. That's the big declaration. And we've all seen that segment. It did change. Doc's talked about it. We've talked about this numerous times over the last several months. All right, response number 16. Plaintiff objects to defendant's attempt to characterize ma'am. The series is in the record and is the best evidence of what is in it, and it believes or belies defendant's characterizations of it as a fair or balanced. And it gives the dockets, and that docket 120 through 10, 1 through 10, that is the series that they turned into the court. Moreover, the overwhelming weight of ma'am tells the story that those who believed the framing defense were fooled by corrupt law enforcement officers. Okay. 17. Ma'am shows plaintiff denying in sworn testimony that he planted evidence to frame Stephen Avery, and that's from the Riccardi Declaration. Avery trial day 7. It gives the examples there. Response to number 17. Plaintiff denies that his testimony was, as represented in ma'am, is accurate. As plaintiff has reiterated numerous times in this case, his testimony was heavily edited, including by eliminating from this denial the response, quote, "That's ridiculous," and "No, I have not," end quote. The edits to his testimony have been confirmed by Maura Demos in her deposition, and it gives the docket number. 18. Nishimura has attested that, quote, "Ma'am included not only the fact that Avery accused law enforcement of planting evidence to frame him for Halbach's murder, but also the jury did not find this accusation credible, that it convicted him, and that his post-trial motions were unsuccessful," end quote. That's from the Nishimura Declaration. Response to 18. Plaintiff objects to the testimony as it represents merely defendant's attempt to characterize ma'am. The series is in the record and is the best evidence of what is in it. It gives the dockets again. We're just vomiting the same lines. Moreover, because numerous viewers did so interpret ma'am, and anyone who views it, it can see what it does. Del Dio and Nishimura's testimony is at odds with the plain reading of ma'am, so their testimony is not credible on its face. It is also inconsistent with Netflix creative team notes, including Netflix's direction to Chrome that the series was to be crafted in such a way as to ensure that, quote, "the audience should be feeling more intense anger, sadness, bewilderment, and perhaps even fury at the jury's decision," end quote. And the docket 3. 19. As shown in ma'am, Avery's attorney Dean Strang's closing argument at trial emphasized that the defense's theory was that officers planted evidence, quote, "to ensure the conviction of someone they've decided is guilty," end quote. And it gives the ma'am episode 8 and the Riccardi Declaration. Response number 19. Plaintiff disputes that the paraphrase mixed with partial quotes accurately characterizes Strang's closing argument, which indicated that when officers plant evidence, they do so to ensure conviction of someone they've decided is guilty. He did not make the statement that any particular officer in fact planted evidence. And that's from the Riccardi Declaration. Number 20. Kratz noted in his closing that it shouldn't, quote, "it shouldn't matter or not that the key was planted," end quote, because, quote, that key in the big picture and the big scheme of things means very little, end quote, compared to the bulk of evidence against Stephen Avery. It gives the ma'am episode. I'll read the response, then we'll chat just for a second. Response 20. Plaintiff does not dispute that Kratz made the statement in issue, but objects to ma'am as evidence. Well, he ran from the key. Anyone want to comment on that?
Well, I mean, here's a classic example, guys, in which the individual that did more damage to Colborn and his integrity was not the filmmakers, but the prosecuting attorney himself. Because the prosecuting attorney now put the spotlight squarely on Colborn by saying, hey, look, the key looks really suspicious, but set it aside. It doesn't matter in the grand scheme of things. And of course, what is the trial all about? The trial is about questioning the integrity of police officers that should have never been there in the first place. So if the prosecuting attorney in his closing argument is saying, please put aside the key, doesn't really matter, then the jury surely must be thinking, wait a minute, if he's now admitting that these fine officers planted the key, what else did they plant, right? So the damage was not by Netflix, it was not by the producers, it was by the state's own prosecuting attorney.
They had to be thinking that, and not only the integrity of them, but then you have to look at the overall, the integrity of the investigation itself. So you're right. If they planted the key because they thought he was guilty, he did it. We just don't have everything we need. We'll just help the case along a little bit. Well, what else did they do to help the case? And that's
correct. And that's the argument that Strang used right at the beginning. Remember what Strang said? He goes, they planted this evidence because in their mind, the officers believed that Stephen Avery was guilty, and Kratz just gave him a get out. He just led them up the garden path and essentially agreed with Strang, which was incredible.
Yes, it was. Absolutely. Anyone else got comments? Anything from the chat? We beat this one pretty hard, but it bears beating because in many ways, this is another heart of those cases, many hearts, but this is another part that's the heart of the case, is the integrity of the investigation, which can't forget. You had Link, Colborn, and alien man, Kaharski, get up on the stand and testify about that damn key. And there's no way around that. So, I think this is just another really bad point, bad lawyering that they're pointing, because the key...
Sorry, Alice.
It's pathetic, and they're repeating, they're rinse and repeat, and it's getting freaking tedious now. And if we are seeing it, I'm hoping to God that the judge is seeing it that way as well, because how can Netflix or the documentarians change what Jerry or Dean said in their closing arguments? You know what I mean? They had to blame somebody. They had to point the finger at somebody, and they never said that the police murdered anybody. They planted evidence, but no murdered anybody. So it's just a pile of shite, and it's fucking ridiculous. It really is ridiculous now.
Well, as Doc pointed out, they went out of their way to say they didn't harm Teresa. They did say that. So let's see where we're at. Yeah, we're not quite halfway done. Now let's continue. Number 21. Some members of the public who watched Making a Murder were left with the question about whether Avery was guilty and whether officers planted evidence. For example, see the big declaration, 31, Griesbach. Quote, I've debated this for a week with my wife and children, and in my own mind, I'm convinced he is guilty. I said the same in the interview I sent you. But I'm nowhere near as certain that the cops did not plant evidence to bolster their case. End quote. That was Griesbach, if y'all remember. Big declaration, Griesbach, quote, I went into the documentary determined to see through any bias the film might imply or employ, but I came out of it more conflicted than ever, not so much as to either defendant's guilt, but whether they received a fair trial, end quote. Declaration, deposition transcript of Brenda Schuler. Testifying that ma'am raised questions thinking Avery was not guilty. She researched them and she concluded that Avery is guilty. Okay. Response 21. Plaintiff disputes the relevance of statements by his former counsel and by Ms. Schuler. Of course you do. And notes that both ultimately revised their opinions. See document 315, the Griesbach Declaration. Moreover, numerous members of the public obviously concluded after watching ma'am that plaintiff planted evidence and or killed Miss Halbach. I never concluded that, and I've watched the damn thing several times. Number 22.
Andy's too stupid to commit murder. Come on.
Yeah, absolutely.
Jesus.
I know, it's crazy. Number 22. In Making a Murder, the filmmakers took steps to further show the viewpoints of the Halbach family, law enforcement, and the prosecution by including, among other things, footage from the press conferences, legal proceedings, and news reports featuring their opinions. For example, the Riccardi Declaration 13, Halbach family, prosecutors, scenes in ma'am that directly push back against Avery's planting allegations. See also, ma'am, episode 3 gives a time frame. MTSO undersheriff criticizing Avery's planting accusations against officers and characterizing them as quote unquote impossible. Ma'am, episode 1 gives the time frame. Multiple scenes in which the prosecutors from Avery's murder trial push back against Avery's planting accusations by, among other things, calling those accusations quote unquote despicable and deplorable. And then, ma'am, episode 7 gives the time frame, scene in which a member of the media calls out Avery's criminal defense attorneys for accusing plaintiff of planting. Ma'am, episode 8, newscast in which anchorman reads plaintiff's prepared public statement following the jury's guilty verdict in Avery's murder trial. And it gives another docket to 295. Response number 22. Plaintiff disputes the defendant's characterization that they took, or quote unquote, took steps to show the viewpoints of those described in any manner except to characterize them as antagonists to Avery. Chrome sought to have viewers, quote, kicking themselves, end quote, for believing officials in early episodes. Gives the docket 330, Manhart 149, and were included to let them, quote, have their day, end quote, as a prelude to retelling their perspective by, quote, our more reliable narrators, end quote. For example, Avery and his advocates thereafter. Jesus Christ. See, the underlying events. Susan, you want to read a few of these, starting with 23, the relevant underlying events?
Jack, I'm too tired. I'm sorry.
That's okay. That's quite all right. That's not a problem. Alice, you want to read a few of these? I may have put Alice to sleep. That's all right. I'll read a few more, and then we'll go from there. Number 23. While serving the 60-year prison sentence in 1995 to 97, Avery filed multiple unsuccessful motions for post-conviction relief, relying on DNA evidence that revealed the victim. Penny Berenson's fingernail scrapings came from a DNA profile that matched neither Avery nor the victim. Avery argued that the Sheriff's Department had information that it failed to disclose to Avery regarding an, quote, alternative suspect living in Sheboygan County who matched the description of the perpetrator, end quote. The court denied the motion and Avery remained incarcerated for 7 more years. State v. Avery. Response 23. Plaintiff does not dispute that the cited cases generally so states, but denies that anything concluded in that case is relevant or admissible evidence in this case for the truth of any matters asserted therein.
And that's exactly what Kratz was alluding to, because he knew how powerful that the 1985 case was and what happened to Stephen. So Kratz, remember in his opening statement, says whatever happened there and the exoneration has got nothing to do with this case. Hence, what he was trying to do was remove the motive from law enforcement then and there.
Absolutely, Doc. 100% agree. He was really adamant about that. That had nothing to do with this case. Okay, sure it doesn't. All right, number 24. DNA evidence showed that Gregory Allen, who had committed and been convicted of another brutal assault in 1995, was the actual assailant of Penny Bernstein. See the Riccardi Declaration 100 and the Wisconsin DOJ review. Response 24. Plaintiff objects to the proposed finding of fact as irrelevant and as consisting of numerous layers of inadmissible non-party hearsay and unauthenticated documents. What?
Have you ever in your life heard of a situation whereby law enforcement are deeming as irrelevant what a vicious sexual predator has done over a long period of time, and the fact that Kacerik and Vogel were protecting him? They're deeming it as all irrelevant, hearsay, unauthenticated document. I've never in my life seen anything like this. It's truly mind-blowing.
It's like Crass help. It's like Crass help write this, right?
Oh my God, it is fucking irrelevant. And it was a court that found Stephen innocent because of the fucking DNA that proved that it was fucking Gregory Allen. And they're saying it's irrelevant? Oh my God, man. The judge needs to find this fucking out. He really does.
I agree. All right, Alice, you're back. Do you want to read a few of these?
Yeah, sure.
You can read a few, and Bill Froggy.
Well,
we're on 25, and you can hand it off whenever you're ready, because these are kind of wordy and so forth. So go for it whenever you're ready.
Okay. 25. The Wisconsin Department of Justice determined in their December 2003 Avery review that Manitowoc County law enforcement had evidence that Avery had 16 alibi witnesses and corroborating time-stamped receipts at the time of Penny Bernstein's assault. Riccardi Declaration 100, Wisconsin DOJ Avery Review. Response 25. Plaintiff objects to the proposed finding of facts as irrelevant and as consisting of numerous layers of inadmissible non-party hearsay and unauthenticated documents. Number 26. The Wisconsin Department of Justice determined in their December 2003 Avery review that Manitowoc County law enforcement had information that should have led them to consider Gregory Allen as a suspect in the Penny Bernstein assault, including a similar assault 2 weeks prior. Riccardi Declaration, Wisconsin DOJ Avery Review. Response 26. Plaintiff objects to the proposed finding of facts as irrelevant and as consisting of numerous layers of inadmissible non-party hearsay and unauthenticated documents. Jesus. The Wisconsin Department of Justice determined in their December 2003 Avery review that Manitowoc County law enforcement did not investigate Gregory Allen as a suspect in the Penny Bernstein assault. Quote, because the Sheriff's Department had only one suspect in mind, unquote. And, quote, the Sheriff and eventually the District Attorney became convinced that Avery and no one else was the responsible party, unquote. Riccardi Declaration, Wisconsin DOJ Review. Response, plaintiff objects to the proposed finding of facts as irrelevant and as consisting of numerous layers of inadmissible non-party hearsay and unauthenticated documents.
Can I just make the comment?
Yeah.
Can I just comment first? You know what they're getting at? They're basically really pissed off with the filmmakers and Netflix that they included anything about the 1985 case.
Absolutely.
Correct?
Absolutely.
Yeah.
They wanted all of that deleted. And you know what, of course, would have been deleted? The phone call.
The phone call.
Colborn. Correct. They wanted that removed from the documentary.
Jeez, man, it's fucking ridiculous. It really is. Number 28. Plaintiff Andrew Colborn testified in his October 13, 2005 deposition in Avery's civil rights lawsuit in 1994 or 1995. While he was a corrections officer at the Manitowoc County Jail, he received a phone call from someone identifying himself as a detective in another county, who said an inmate in their custody claimed to have committed an assault in Manitowoc County for which someone else was still incarcerated. The jail call, recorded declaration, Avery civil lawsuit deposition transcript of Andy Colborn. Response 28. Plaintiff does not dispute this proposed finding of fact, except that the source materials disclose that the caller relayed that the person at issue was in prison. Docket 120 through 14, Depot 147012, Depot 512. Plaintiff also disputes the use of ma'am as evidence of anything purported to be portrayed in it. Number 29. Colborn, quote, wrote a statement in September 2003 regarding a telephone call that he received in or around 1994 or 95 while he was a corrections officer at the Manitowoc County Jail. That statement was provided to then Sheriff Kenneth Peterson, who told Colborn that he would put the statement in a safe. Docket 270, statement of stipulated facts. And then more cases, the dockets and that where you can find them. Response. Plaintiff does not dispute this proposed finding of fact, but objects to the consideration of the DOJ report as inadmissible, non-party hearsay, unauthenticated by any witness with personal knowledge. Number 30. Plaintiff has testified that he transferred the call to an MTSO detective number but never heard any feedback or response regarding the call. Recorded declaration 102, Colborn Avery deposition. Response 30. Plaintiff does not dispute this proposed finding of fact. 31. Several others in law enforcement have testified or otherwise stated that they believed someone in MTSO, some believed it was likely Sheriff Kasurik, relayed a message to plaintiff that plaintiff should not worry about the jail call because MTSO had, quote unquote, the right guy. Jones's memo produced by Wisconsin's Department of Justice, and then more citing where you can actually find them. Response 31. Plaintiff objects to this proposed finding of fact as consisting of non-party hearsay that is inadmissible in this case for the truth of the matters asserted therein. 32. Avery filed a civil rights lawsuit for $36 million in this court in 2004, asserting claims against former Manitowoc County Sheriff Thomas Kasurik and District Attorney Dennis Fogel for violating his constitutional right to due process before targeting him and failing to investigate Allen, focusing the investigation on Avery because of personal hostility against him. failing to provide exculpatory information to his defence counsel, and continuing to withhold exculpatory evidence during his incarceration. Response 32. Plaintiff does not dispute this proposed finding of fact, but disputes that the allegations in Avery's complaint may be considered any evidence of any of the matters asserted therein, and as hearsay.
Yep, that's, you can see what they're doing. They're trying to do a peg L. They're trying to completely whitewash anything to do with the 1985 case and
Yeah.
the exoneration.
And that damn phone call.
Yep, correct. They want that wiped out, completely wiped out.
It just makes you so fucking angry. It's unbelievable. The lengths and the shit that they go through to cover their fucking arses because they've made the fucking biggest mistake in their careers. Number 33. Calumet County took over the investigation of Teresa Hallback's murder to avoid the appearance of conflict of interest issues related to Avery's ongoing lawsuit against Manitowoc County. Press conference introducing Ken Kratz, Calumet County District Attorney, as a special prosecutor in the case. Response 33. Plaintiff objects to the proposed finding of fact as relying on non-party hearsay as presented in MAM, and which is not admissible evidence for the truth of the matters asserted therein. 34. Manitowoc County Sheriff Ken Peterson was recused from the Teresa Hallback investigation. Deposition transcript of Kenneth Peterson. Response: plaintiff does not dispute this proposed finding of fact. 35. Beginning on November 5th, 2005 through November 8th, 2005, MTSO deputies plaintiff and Link took part in several days' searches of the interior of Stephen Avery's trailer and garage and only found the Toyota key on November 8th, 2005. Response: plaintiff does not dispute this proposed finding of fact. No, because you can't fucking dispute it, you arsehole. 36. As shown on MAM, plaintiff testified at trial that when searching the bookcase in Avery's bedroom on November 8th, 2005, he was handling it, quote, rather roughly, twisting it, shaking it, pulling it, before Link discovered a Toyota key on the floor later that day. The officers then stopped and photographed the key on the floor, recorded declaration. Link's report of finding the key, and that's mere Butin questioning Kaczynski about the theory that the key fell out the back of the bookcase. Response 36. Plaintiff does not dispute the elements of his testimony were portrayed, but dispute that they were presented in context. Rather, his testimony was heavily edited and presented in a manner that did not make sense to listeners. The intensive edits were confirmed by Moira Demos in her deposition. Docket 320 in Demos Depot. 37. The initial criminal complaint in Avery's case identified Deputy Kaczynski as the officer who found the key to Teresa Hallback's Toyota instead of James Link, Riccardi and Demos declarations. 30. Response 37. Plaintiff does not dispute this proposed fact, but objects to its relevance to the issue to be decided in this case, and objects to consideration of the contents of the initial criminal complaint as hearsay.
Yeah, but we all know how relevant. You know why they did that? Because they're trying to put an arm's length between Link and the key. And they're now saying that Kaczynski found the key, hence totally obliterating both Link and Colborn in any form of complicity in planting. Very, very clever.
Yep. That's
Yeah.
because Kacharski's the one that turned the report in and left their name out, basically left their names out of it.
Correct. And Colborn never mentioned the key in his report.
Nope.
No.
Yep. Interesting.
38. In a January 30th, 2007 pre-trial order admitting evidence of a vial of Avery's blood taken in 1996, Judge Willis explicitly identified plaintiff as one of the two Manitowoc officers that the defence could accuse at trial of planting evidence. Quote, the court does not understand Avery will be attempting to implicate any members of the Sheriff's Department other than Mr. Link or Mr. Colborn in any frame-up, unquote. Response 38. Plaintiff does not dispute that Judge Willis ordered so stated, but denies that the language quoted is evidence of how Avery's attorneys argued to the jury at trial, the best evidence of which is the transcript of those arguments. 39. Plaintiff produced no evidence contemporaneous to the underlying events at issue in this lawsuit. Declaration of Megan Fenzel. April 12, 2022, meet and confer correspondence confirming plaintiff did not retain or produce documents relating to the events that were the underlying subject of MAM. Response 39. Plaintiff disputes this proposed finding of fact. The contemporaneous evidence produced by plaintiffs is summarised in the declaration of Deborah L. Brusick, filed as docket 354. 40. Plaintiff acknowledged that unless someone was in the room with him at the time, they could not know with 100% certainty whether he planted Teresa Hallback's Toyota key in Avery's bedroom and would have to trust that he was telling the truth in his trial testimony. Fenzel and Colborn declaration and Colborn's deposition. Response 40. Plaintiff disputes the defendant's characterization of his testimony. Plaintiff's testimony speaks for itself and is set forth below.
We can read that out.
Yes, I do.
Well, I was going to say, yeah, okay. I'll read the question. If I can read it here. Okay, but unless Mr. Griesbach was in the room with you, or any of us sitting here today were in the room with you, none of us can know with 100% certainty, correct?
I would think that I drove that point home in the trial. And based on the subsequent conviction, I believe the jury was convinced of it.
We would have to trust you, correct, Mr. Colborn?
Yes, you would have to trust that I was telling the truth under oath.
You know, they're really on this key, aren't they?
Yeah. Yeah. If somebody wants to take over for the last few pages, that's absolutely fine.
Sure. Go ahead, Doc. You had a comment?
Yeah, I did. My comment is, between me and you and everyone in chat, it would have actually been better for the state to have not presented the key, to have withheld that evidence and held it back, because the key has now become a thorn in the side of the state. People look at the key for what it is. It is so obviously planted. It is not funny. And now to hear all the crap coming out of Colborn to say, well, I'm telling the truth, and of course I did this, and of course I did that, and yeah, the jury believed me. I tell you what, not even Kratz believed them. That's how bad it was. So I think the key really backfired on them. It really did.
Yeah, I totally agree. Hold on just once. Rhonda, or who feels like reading? You're certainly welcome to jump in. Rhonda, Doug?
Great, I've had a break.
All right. Go for it. Start there whenever you're ready.
41?
Yeah.
Okay, I'm just going to read off of the YouTube screen. 41. To the extent that there are any inaccuracies in the series, such inaccuracies were inadvertent, and the producer defendants entertain no doubts that MAM accurately captured the gist of the parties' contentions. And then it's just got all the pages of Riccardi's declaration and Demos. Response to 41. Plaintiff objects to the testimony as it represents merely defendant's attempt to characterize MAM. The series is in the record and is the best evidence of what is in it. Dockets 120 through 1 and through 120 through 10. Moreover, because numerous viewers did so interpret MAM, and anyone who views it can see that it does so assert defendant's testimony is at odds with plain reading of MAM, so it is not credible on its face. 42. The producer defendants believe that MAM accurately portrays the opinion commentary from various individuals sympathetic to Avery, Riccardi, and Demos declarations. Response to 42. Plaintiff objects to this proposed fact as a mere legal conclusion that mischaracterizes statements as opinion that were factual in nature as the statements themselves disclose. Plaintiff's proposed findings of fact, document number 287 at paragraphs 3 through 54. Point number 43. The producer defendants believe that any perceived omissions to MAM were due to the challenge of compressing 30 years of history into 10 hours of television and did not alter the meaning of the series or present Avery's criminal defense and the opinions of Avery and his defenders as, quote, actual and unanswered facts, end quote. And that's Riccardi and Demos declarations. Response to 43. Plaintiff objects to the defendant's purported self-serving beliefs as irrelevant to the issue in this case as legal conclusions and to any attempt to characterize in such cursory means the series, which is in the court record at document 120 through 1 and 120 through 10 and speaks for itself as the best evidence of the series. 44. There are numerous scenes in MAM that reflect negatively on Avery. A scene with a statement by Chuck Avery, Stephen Avery's brother, stating that he was pretty positive Stephen murdered Teresa Halbach. And then a scene in which Stephen Avery's sister, Barbara Yonda, tells Stephen, quote, I hate you for what you did to my kid, all right? So you can rot in hell, end quote. MAM episode 5, scenes showing Avery's nephew, Bobby Dassey, testifying against him at his murder trial, with Dassey shown as being one of the prosecution's most important witnesses. And that's in MAM episode 7. A scene showing, or rather in MAM episode 7, a scene showing Teresa Halbach's brother, Mike Halbach, opining that he believed Avery was guilty. MAM episode 1, Morris allegations of indecent exposure by Avery. MAM episode 1, Morris's allegation of I read that one. Avery's cat burning and conviction and probation. MAM episode 1, Avery's reckless endangerment of Morris. MAM episode 1, Avery's criminal charges for reckless endangerment of Morris. In MAM episode 1, an interview in which Judge Hazelwood, the presiding judge in Avery's 1985 trial, opines that Avery had a propensity for violence against women, which, other than Sandra Morris, did they have reports of Stephen, of DV, domestic violence against Stephen, with his wife at the time? Because I don't remember.
I think they just had some loud arguments, but maybe someone else can correct me there.
Okay. Because this propensity for violence against women thing always kind of, I don't know. propensity means there's many charges of many facts of evidence proving something like that.
I don't think so.
Okay. I didn't think so either. In Ma'am episode 3, a scene in which Stephen Avery tells his parents that he was going to kill himself if they did not figure out a way to post bail for him. Ma'am episode 6, a scene with Avery opining that the prosecution was going to win at trial. Interviews with various people who opined that violent crime was in Avery's character, along with interviews of people who disagreed with that opinion. In Ma'am episode 1, an interview with a member of the local media who said the arrest of Avery for the Bernstein assault was not a surprise because Avery was one of the quote-unquote regular names on the crime beat in Manitowoc County, and the assault was quote-unquote in character for him. Ma'am episode 8, the jury's guilty verdicts in Avery's trial for the murder of Teresa Halbach. Ma'am episode 9, a scene showing Judge Willis, who presided over Avery's trial, opining that Avery was, quote, probably the most dangerous individual to set foot in his courtroom, end quote. Response to 44. Plaintiff admits that various scenes included in Ma'am discuss Avery's prior crimes, but the crimes were downplayed as explained in plaintiff's prior response to defendant's proposed finding of fact. Moreover, defendants sought to infuriate the audience with the statements of others who criticized Avery and described those who criticized him, including the judge, as biased. Further, defendants described Avery as their protagonist and described their relationship with him as intimate. And there's a link to Crime Story. Defendant Riccardi also testified at her deposition that Avery was Ma'am's protagonist. Moreover, whatever Ma'am's portrayal of Avery, that does not disprove that Ma'am defamed plaintiff. 45. Plaintiff testified in this lawsuit that as an introvert who doesn't like being the center of attention, the act of testifying makes him feel uncomfortable. Probably because he knows he's going to fucking lie.
Yeah.
Or is afraid he's going to fuck up the lie or some such shit. That's the only reason he's uncomfortable testifying. Because you know what? I think if I were a cop who's testified in many trials, and I know that my testimony is going to be truthful and factual to the best of my knowledge, I can see feeling nervous, because it's a new trial, but being uncomfortable, that just doesn't make sense to me from somebody who claims, that he's testified in many trials. I don't know if anybody else feels that way, but it just doesn't make sense to me when I every time I hear that.
But the other crazy thing is that if he was such an introvert, how come he was everywhere? And how come he was first? And how come he was first officer on the Avery salvage site wanting to talk to Chuck if he was an introvert? Right? He embedded himself in the narrative immediately and was everywhere with a camera.
Yeah.
That's right.
Yep, exactly. Response to 45. Plaintiff does not dispute that he testified as described, but objects to this proposed fact as irrelevant and as an apparent attempt to violate the best evidence rule. The best evidence of Mr. Colborn's appearance during his testimony in the Avery trial is raw footage of that testimony. As shown in the videos presented to the court, the appearance of his testimony was altered in ways that changed the manner and presentation of his testimony. Number 46. Plaintiff's former attorney of record, Michael Griesbach, wrote the following in his 2016 book, Indefensible, about the Avery case, discussing the officer's demeanor during depositions in the civil lawsuit. Quote, by the end of the night, I had seen clips of videos from several of the officers' depositions, and I had to admit they looked like they were being defensive. They were not happy about being grilled by a room full of attorneys concerning a very black mark on their department, especially not with Stephen Avery sitting there watching them squirm. Most people do get nervous when being deposed. On the other hand, nearly all of them looked more defensive than they should have if they had nothing to hide, at least in the video clips the documentary chose to include in the series, which I later watched when I later watched the complete video of the depositions of the officers who were most directly accused of wrongdoing, either in the first Avery case or in the second. My concern that they had something to hide, though significantly reduced, was not completely alleviated. This was not simply a case of only selective editing to make them look bad. That was in Vic's declaration. Response to 46. Plaintiff objects to this proposed fact as consisting of hearsay in and inadmissible lay opinion as irrelevant to the issues to be decided by the court. 47. In sworn testimony.
I was going to say, now they're even arguing against their former attorney, Greaseback, saying that what he said is all inadmissible hearsay and don't worry about it.
Yeah.
That's a classic.
Just clawing and scratching at anything.
Yeah, like they see this thing crumbling. I would assume that's how they're feeling by the way this sounds. Okay, 47. In sworn testimony, plaintiffs acknowledge that, by definition, the anonymous people who left him abusive voicemails were unreasonable. From the Walker Declaration. Response to 47. Plaintiff does not dispute that plaintiff testified essentially as described, but objects to this proposed fact as irrelevant to the question whether viewers reasonably interpreted ma'am, as opposed to whether they reasonably interpreted the facts as asserted in ma'am.
Then why the hell did they include it in the second amended complaint?
Oh,
They're arguing against their own complaint now.
This is just so much horse shit that it's hard to read with a straight face. Oh. Okay. Number 48. At the outset of this case, plaintiff blamed ma'am for his divorce, but it subsequently came to light that plaintiff filed for divorce from his third wife after his third wife? That was his third wife?
Yes. Yeah.
I did not know that. I just learned something new in this case. Mind blown. Well, I have a few opinions about that. But filed for divorce from his third wife after engaging in an extramarital affair. I can't say it. It's not coming to me. Statement of stipulated material facts. Making a murderer caused my divorce. End quote. That's in the Walker Declaration and first set of interrogatories. Ma'am has destroyed my 30-year marriage, and the marriage ended in divorce. Declaration of Barbara Colborn, Declaration of Betty Heinzen, and of Paul Kobodlansky. Response to 48. Plaintiff objects to this proposed fact as irrelevant and as improperly attempting to speculate regarding plaintiff's motives for agreeing to a stipulation proposed by Netflix. Plaintiff stipulated that he did not blame ma'am for contributing to the demise of his marriage for the purposes of this case, not that he did not believe that it did. Plaintiff also objects that the cited materials do not establish that Barb Colborn was his third wife.
Interesting.
Yeah.
Well,
49.
First, he did blame man for the demise of his marriage. I don't know why they put that in there because he clearly did. And, somebody please correct me if they have a Colborn's family tree, but I could swear that he was married for a short time to someone prior to him marrying Barbara. But, hey, I could be wrong.
I'm going to go to my ancestry.com page and start looking up Andrew Colborn, find out how many women he was married to
Awesome.
and for how long. I just think that's crazy. Well, if he was married to Barb for 30 years, those other marriages must have been very young when he was very young and must not have lasted for very long. But
Right.
anyway, 49. Plaintiff violated the confidentiality of the court order of mediation in this case by telling his friend, Brenda Schuler, a producer of the convicting documentary, about what had happened at the mediation, including the parties' positions. Declaration of Kevin Vick in support of expedited motion to depose plaintiff.
Oh boy, Doc, you got
Oh,
anything? You
boy.
got anything there?
Yeah.
Brewing, Doc.
I'm keeping my mouth firmly shut, Jack 61.
Yeah, I think I will too. I think I'll just let that one slide off.
Yeah, we'll pretend like we didn't hear that. Response to 49. Plaintiff objects to this proposed fact as irrelevant to the issues before the court in this case as a blatant attempt to smear the plaintiff. Of course, that's what he thinks. Moreover, plaintiff denies that any information allegedly was disclosed that is not already public record or that would have been evident from the continuation of the case. For example, it did not settle. God.
Okay.
50. Plaintiff filmed an interview for a not yet released quote unquote counter documentary convicting a murderer on March 2nd, 2018, 2 weeks before he ended his employment with MTSO and was permitted to publicly speak about the Avery case. That's in the Vick Declaration. Recapping the interviews. And he was stating an inability to speak publicly until employment ends March 16th of 2018. And there's some exhibit numbers. Convicting a murder appearance release from signed and dated March 2nd, 2018. Response to 50. Plaintiff objects to this proposed fact as irrelevant to the issues before the court in this case. Subject to the objection, he disputes the proposed facts. Plaintiff had permission from his supervisor to participate in the interview. Well, there you go. So just wash our hands of that one because it doesn't matter. 51.
But don't you find that rather amazing that when the filmmakers were there, they obviously asked Colborn if he wanted to participate and give his side of the story, as well as other members of law enforcement. They obviously refused or were given a gag order not to participate. And it's interesting that Colborn now mentions the fact that I was given permission to talk in the counter documentary. Whereas, don't you think it would have been more impactful in situ for Colborn to have said what he wanted to say back in the documentary as millions of people saw it? It would have had a greater impact rather than trying to do it through the back door and doing it this way. It's crazy. And now with this lawsuit, the spotlight is firmly on Colborn again, and it's got the potential to backfire and make him look even worse than what he did in making a murderer. Think about that one.
Absolutely agree.
Yep. Yeah, that's great point. Okay, 51. The deposition of plaintiff's former boss, Sheriff Ken Peterson, revealed that after Peterson instructed plaintiff in September 2003 to prepare an incident report regarding the 1994-1995 jail call, plaintiff instead utilized a statement form ordinarily utilized by civilian witnesses, not MTSO personnel, which Peterson believed had the effect of burying plaintiff's report to make it less likely that others would locate it in the future or learn of its content.
Boom.
Response to 51. Plaintiff objects to this proposed fact as irrelevant to the issues of this case and as contradicting testimony. Mr. Colborn testified that he was asked to prepare a statement, which he did. Additionally, Lank testified he also was asked by Sheriff Peterson to prepare a statement. Sheriff Peterson's testimony speaks for itself.
Yeah, but he put it on a civilian form and not a regular officer's form. So they just completely deflected that and didn't answer it at all.
Yeah, exactly. Well, that's SOP for these guys: deflect and don't answer.
Yeah.
Plaintiff's second amended complaint falsely alleges that defendants knew plaintiff's written report concerning the phone call was not left in the sheriff's safe, but chose to include Glenn's mistaken belief in order to further the false narrative. But plaintiff now has been forced to admit that his statement was kept in a safe in the sheriff's office, just as contemporaneous December 2005 reports from the Wisconsin Attorney General provided all along. Statement of that's okay. Okay. Response to 52. Plaintiff objects to this proposed fact as to defendant's gloss and argument contained therein rather than fact, and as to defendants improperly speculating regarding matters that were resolved by stipulation. Plaintiff further objects to the DOJ report as unauthenticated non-party hearsay.
Oh my God.
Wow.
Can you believe that? As an unauthorized non-party hearsay.
It was kept in the safe,
Wow.
and they were trying to say no, it wasn't, and then come to find out, oh yes, it was.
Yeah. But it's irrelevant to this case.
Uh-huh.
When he's made such a big deal about it throughout, it's
irrelevant now.
Now it's irrelevant. Yeah. God. 53. In this lawsuit, plaintiff has at times refused to admit that Stephen Avery's criminal defense at his 2007 trial included a theory that law enforcement planted evidence to frame Avery. These refusals persisted even when confronted with his contradictory prior writings and the second amended complaint, specifically referencing the Avery's defense's planting theory. In the Colborn Deposition, refusing to stipulate that planting defense was a central theme at Avery's trial. And in other part of the deposition, stating that his position was that he didn't know what the theory was at trial and was never accused of planting evidence. Okay. Acknowledging that he made statement to I'm having a hard time with acknowledging that he made statement to the news to respond to negative portrayal at trial, but still insisted he was never accused of planting evidence. And acknowledging requests for admission introduced as Exhibit 11 that denied that Avery's defense, quote unquote, contended at trial that law enforcement planted evidence. And another part discussing Brenda Schuler's testimony about how plaintiff felt wronged for being accused of planting evidence at trial. And then again, refusing to acknowledge planting theory. And then on from there, reading Avery Day 7 trial transcript at pages 201 through 204 with Kratz and Strang discussing planting theory with the judge, yet still not agreeing that the defense had a plaintiff theory. And then refusing to acknowledge planting theory when reviewing email plaintiff wrote to lawyer Patrick Dunphy, describing being accused of planting evidence. And then after watching ma'am excerpt of the Avery trial with crass questioning plaintiff if he planted evidence, again denying that he was accused of planting evidence at trial, and then acknowledging there were implications about police misconduct surrounding the Toyota key, but claiming he thought it was procedural defects rather than a planting theory. What?
Okay. That's funny.
They were procedural defects rather than a planting story theory. Oh God. Okay. And then emails with Patrick Dunphy explaining his ire at Buting and Strang. Quote, in short, the defense was that I and another now retired police officer planted the evidence that led to Mr. Avery's conviction, end quote. And then attorneys and Judge Willis discussing the planting theory. Those are all different excerpts from his deposition. I believe
it was.
So, response to 53. Plaintiff objects to this proposed fact as irrelevant to the substantive issues in this case on multiple levels, including as to what plaintiff believes on matters that are before the court for decision. Subject to the objection, plaintiff's counsel has explained to defendant's counsel on multiple occasions that review of the Avery trial materials shows that defense counsel in fact did not directly accuse plaintiff of planting evidence at Avery's trial. They argued that if the jury believed that it was possible that one or more officers planted evidence, then there was reasonable doubt and Avery should be found not guilty. Further, plaintiff's prior lay understanding of a series that defendants repeatedly note he has not watched is irrelevant to his understanding of what he presents now. Ugh, Jesus Christ.
Yeah.
I just can't, like, that line that's talking about him and watching that he did not watch the documentary means to me that he has no business, in my opinion. He should not have been allowed to file this ridiculous lawsuit.
I agree. And this thing about the key being procedural defects. What?
Procedural defect? What the hell is that?
I think he's trying to basically say, hey, I checked the MTSO manual. Yeah, of course we can plant it, but I never knew it was called planting. I just thought it was a procedural defect. I wasn't aware of that.
That's a whole different story now.
So now he's got a third or fourth story because he's changed his story in the letter that he sent to the sheriff.
To his boss.
Yes.
That's right.
Yeah. Yep. Oh my God. Okay, 54. One Avery juror has stated publicly that he believes plaintiff testified falsely at Avery's trial and that plaintiff, quote, looked like he was sweating and he wasn't being honest or he was trying to cover up a lot of things on the stand, end quote. And that's from the Rick Marr interview.
Yep.
With Mark. Response to 54. Plaintiff objects to this proposed fact as consisting of hearsay and irrelevant lay opinion and as irrelevant to the issues in this case, except that the unrelenting vitriolic attacks on Mr. Colborn evidenced in evidenced in this and other irrelevant facts set forth in defendant's filings may amount to further evidence of actual malice, as statements following publication can be considered malice and express malice is a factor that can be considered in the actual malice inquiry. Okay.
Why don't they say malice one more time? Jeez.
I know. Why don't you twist the law to or the statute to fit your narrative? That would help too.
Yeah.
After 55, after deliberations, it was revealed that when the jury was initially polled at the outset of deliberations, the vote was 7 not guilty, 3 guilty, and 2 uncertain. And that you can find in MAM episode 8. Response to 55. Plaintiff objects to MAM as evidence of any matters allegedly portrayed therein. It is hearsay and edited hearsay at that.
Oh my God.
Dated this 9th day of December 2022. It was written by Miss April
Of course.
Rockstead
Yeah.
Barker.
Yeah. She's pretty rough. She's not as bad as Burnett. God almighty.
Oh my gosh.
That was rough.
Like, I don't even. There's nothing that I can even say that hasn't already been said, but there were some things in that last few, in those last few points that were like, what is he talking about? What
I
are
know.
they? I don't understand.
I know.
Oh
It's
my gosh.
absolutely nuts. And I hope that, well, I don't wish anything on a good judge, and Ludwig seems like a really good judge. He has other cases too. This is not his only case. So I'm sure he's managing many other cases at his level in the federal level. So, when he gets his hands on this and he goes through reading, I just don't know. I'm not smart enough, and I've not been exposed to someone like him and see how they approach what they do on a day in, day out basis, right? I just have to wonder, and I'm sure he has clerks that help him and others. I have no doubt he's got a few that help him. But I just can't imagine that he's going to look on any of this favorably of what these last several documents that they filed. I just can't. And I'm talking about the plaintiff.
Yeah, Nan's Life in chat says, well, it isn't hearsay if it was actually logged by the court reporter when defense asked to poll the jury.
Well, yeah, I agree. I agree, Nan. But what they're trying to say is that because they edited the documentary, and not just Colborn's, from anything from Colborn, but others as well. So it can't be believed at all, which is complete bullshit. It's, again, they're trying to throw MAM under the bus.
Ma'am, the person, you mean? Right?
Yeah. Well, yeah, of course, MAM, the person. Absolutely. So I got to tell you, this case, it was pretty interesting, and we had some fireworks back 6-7 months ago, and now it's just a rinse and repeat, and it's become so God.
Well, it's like they think if they keep saying the same things over and over, that somebody, the judge or somebody, a jury, which I don't believe it's going to get to, although I think it would be interesting to see a jury trial. I don't want that because I'm pretty much done with this case, but it would be interesting. But it's like they're trying to, make everybody believe what there's. It's just, and everything that he's bringing is just so ludicrous to me. It just
You can't help.
so much.
I can't help but think that what what Doc was talking about the other night. You were talking about trial, Rhonda. I can't help but believe that Manitowoc County, Manitowoc Sheriff's Department, and even the state and the DCI do not want this exposed like this, because if it goes to trial, it's going to get worse.
They're screwed. Yeah, it's going to be bad for them. Of course. Listen, when I say this, it's not because I think something should happen or hope something happens, because I don't. I don't like Andrew Colborn. I think he's a mousy, whiny little pussy mouth. I'm trying to.
Fanny.
But Fanny, yes, he's a fucking Fanny for real. And but I'm surprised there haven't been attempts on his life. I know that sounds drastic, but I'm really surprised that there hasn't been attempts on his life. Now, he might say that there has been, but and I don't think that those attempts would come from just any old average citizen either.
Oh no,
And
it'd
I
be
know that's really a far, yeah,
somebody. What do they call it?
connected.
Highs and lows. Somebody that's not balanced. What do they call it? Damn it, I can never. I always forget the name of what that condition is called. You know, they have really high highs
Oh,
and
bipolar,
thank you.
manic depressive, manic. Yeah.
Sure, you get anyone that's known someone that, and I've known a few through in my real life career that I managed, and on medication, they're generally really productive, and not many people can keep up with them when they're off their medication. Depending on their life situation, it can go completely downhill and sideways, like in an instant.
Right. Yeah. Yeah.
And we've got a new person that's joined us in live chat, Kimberly Neal. Hello, thanks for coming.
Kimberly?
What would be the most efficient way to discover who is funding AC's legal team? That's a good question because I really don't know.
I don't believe, I mean, that's not going to be public information that we could FOIA. So,
No,
but I would say that it has to do with convicting and, slash Brenda Schuler, somehow.
My guess is, and this is just pure speculation, would be Andrew Hale, which is, he's in conjunction with Sean Reck in producing Convicting Murder. But Andy Hale, he is a lawyer and he has defended many Chicago area police officers over his career. That's a potential. I don't. Yeah, absolutely. I mean, and hey, I'm just saying that, but I don't know. Yeah, Andy Hale, and I think he. Again, I'm speculating here. I don't know this is fact, so please don't anyone take what I'm saying with fact. But I think that there's a connection with, when Sean decided to do this documentary, that this Andrew Hale helped with the financing part of it, because he's been pretty successful in defending these police officers.
Oh, okay. So, okay, I see what you're saying. I gotcha. Okay. Yeah, and I mean, they basically, well, it can't be there's no way that he would take this on a contingency. There's just no way with all the documentation and motions and second amended complaints and all. There's no way it could be on a contingency. So,
we've got
very beginning.
We've got to be
in the very beginning. I did think that it was possibly being done on a contingency,
sure.
But the farther this has drug on and the worse it's gotten, there's no way.
Yeah, we're almost to the date of 4 years since it was filed. Maybe this is the date. I don't know. It's close to it, but what did they say? This has been like many documents ago now. 150,000 pages of documents have been filed, and that was probably 40 documents ago. Hell, I don't even remember now, but there's been a lot more files since we read that Lita had put in to one of her documents, over 150,000 pages of documents. So
right.
Who's paying?
Yeah.
He's paying these lawyers.
For this.
Absolutely. Because it's not cheap.
Yeah. Hell no. Especially with all of the twisting and turning they're having to do to make these motions and these filings sound legitimate. It's too much work.
And they just, to me, the last several that they have turned in, it's just throwing everything they can at the wall, see if the judge was going to bite on any of it. I can't believe he will. I just can't.
I can't either. It doesn't seem logical to me that he would allow this case to go further.
Behind the magic. Alice would say, "This is a load of shite." Yeah, no doubt about it.
Yeah.
All righty.
And I'll just,
go ahead, Rob.
yeah. I was just gonna say, and I'm just gonna say it's a load of shit.
Me too.
It's just
a truckload.
Yeah. Yeah. Okay.
Yep.
Oh,
Well, I mean,
interesting.
Yep. Well, it has been very interesting, and but at this point, and like I said, the last, I don't know, many things that have been filed from the plaintiff have been really pretty terrible, in my opinion. Bad lawyering, and to me, it's just cut your losses and move on, because nothing in it works. Nothing. So anyway,
and they should be embarrassed and like almost humiliated by what they're doing and what they're saying in his so-called defense. It just, or well, argument, I guess is the right word. It's just, and the average person is not reading all of this stuff that we're reading. They might, I don't know what they're seeing in Wisconsin regarding this case, but there's just if people were reading everything that we're reading, and they would all just be mind blown as well. I can't imagine anybody believing any of this to be legitimate, trial worthy information or whatever.
Yeah, I can't recall anyone posting anything on Reddit or other social media about this lawsuit. I'm talking about the Herald Times and the Post Crescent. I don't remember seeing anything, and I'm not saying there hasn't been, but generally when someone from that region, like somebody in law enforcement of the Avery or Dassey family, if something's in the paper or the media, we get notified. Somebody gets it to us.
Right.
I haven't seen anything.
Yeah. Kimberly Neal said, would a private investigator be able to discover who is funding AC's legal team?
I don't think so, not unless you were hired as part of that team, and even then, even then, I doubt it.
It's like a private contract, I think, in a sense.
It was an attorney-client privilege. I mean, you might be able to ask Brenda.
Yes.
Brenda might know.
Yeah, Brenda might tell you.
Did I say that out loud? That was mean.
I'm sure all we'd have to do is ask her.
Right.
That's about the only thing left that I'm interested in is what's in those emails from Brenda. That's been sealed. That's the only thing that I'm interested in at this point with this case. But that's just me.
Yep. All righty. Well, we've been at this for 3 hours and 40 minutes to get these two documents, and of course we've had some great discussion, but this is the last two we have for now. I have no doubt there's going to be more filed. I did. Sure. I don't know if I said this or not, but I did ask Sherry to look at the schedule for this, the court docket, to see if there's a hearing scheduled. There isn't. The last one was, I think somewhere around. It was in July. I can't remember the day. It was around close to the time that Griesbach resigned off the case. Yeah, so it's been we're 5 months in since I think we've had a hearing. So I wouldn't be surprised to see something maybe after the first of the year soon.
Yeah. Yeah, sometime in the first of the year. I'm sure Ludwig he's going to need some holiday spirits before
God, I mean, I'm sure he has cases worse than this, but this is bad. I would imagine, in his career, I'm sure he's seen some really bad documents come before him in a civil matter. But these are bad to me. They're terrible.
Well, this whole case is just 100% gratuitous, in my opinion.
Yeah.
Yeah. Bethany in chat said, when is Zellner supposed to respond? Well, Kathleen has to ask permission from the court. What she has done, she's asked permission from the court to file a response to the state's response. So there's nothing Kathleen can do until she gets permission from Suck at This.
Yep. Judge Angie's got to respond and say yay or nay, and we haven't heard anything yet.
Yeah, so it's all just a waiting game, which I don't know why she's taken so long to say, aye, you can reply, which she's entitled to do, if I remember right. She's just taking the piss, in my opinion, Beth. But there's nothing Kathleen can do until she comes back and says, aye, she can file her response. So it's all down to Suck at This at the moment.
Yeah, I think that I think also included in Zellner's thing to the court was an amended. I think she wants to amend something, so that may be why it's taking a little bit longer. So we're just waiting to see. Hopefully, we'll hear something here this week. So anyway, I propose that we get out of here and have some dinner. Maybe crack a beer or Coke or coffee or whatever your choice is. Yeah, absolutely. Because I know I'm getting hungry. I didn't eat dinner, but that's all. Hey, that's my fault. That's not anyone else out there. So, upcoming schedule for now. This coming week, if anything, if we get any more documents, we'll try to get them out there quickly as soon as we can, so we can try to keep up and not get buried. But we do have holidays coming, so we'll just see. We'll see what happens. Did you want to announce anything about this coming week potentially, Rhonda, or no?
Oh, well, I'm going to Thursday, because I've been away from my own YouTube for several months now. So I'm going to do something on Thursday. I don't know if it's going to be, I mean, I just want to kind of update everybody on what's going on with Daniel and the case, which is really nothing because we're just preparing for post-conviction at this point. But I just kind of want to do a catch up and, kind of let everybody know where I've been, what's going on, and what's coming in the future with the case, and all that. So I'm sorry, I just lost my train of thought. But anyway, so yeah, something Thursday. It won't be anything like incredibly formal about the case. I know I left off with the last accuser that I have all the information on is Shardarian Hill, and so I don't expect that I will do that until after the new year, or maybe the week after Christmas, maybe, possibly, but I will do a little catch up on Thursday to kind of get back into the swing of things a little bit. So just look for that on Thursday.
Awesome. That's good. Well, then on Saturday, we'll be doing part 2 of Skinny and Reading with the Crew, Doc and Neverly and everyone. That is Christmas Eve, but I don't think it's going to take too long to finish out what we've got with what's left. Not too much left of it.
Slightly less than open mic, but yeah, hopefully maybe an hour and a half max. I think it really depends on how the discussion goes, but we'll try and do a short one. And we'll probably likely take a week or 2 off because it's going to be New Year's and things like that. But we'll make that announcement next week on the program. But keep the comments coming with the Reading with the Crew. Certainly very, very interesting, and I'm sure we've all learned a lot. And I'm certainly learning a lot with the readings that you're doing here, Jack 61, and it's amazing the minutia and utter crap that Colborn and his team have gone after Netflix. It really is pitiful. I personally just hope the judge puts a lid on it and shuts it down right now, because otherwise this is going to go on ad infinitum.
Yeah.
Yeah, I can't imagine he's going to listen to too much more. I really can't.
Yeah, yeah. He's got to put a box around that. You can't have it open ended like this, because you know what? Colburn's team's going to run out of money, not Netflix.
That's for damn sure.
Right.
And again, I cannot believe that anyone in Wisconsin wants this to go to court. I can't believe it.
And I'm telling you what, people like Kasarik and Vogel must be shivering in their boots because they're thinking, holy hell, our names are up in lights again. After all the hard work that they did to sidestep everything that happened, now Colborn has potentially dangled them in front of a shark.
Oh, absolutely.
That can't be good and not be good.
Yep, I agree. Yeah, we'll probably take. Open mic is. That's going to fall on Christmas Day, and I won't be doing an open mic that day. But that following week, we'll see what happens. If nothing is forthcoming as far as Colborn documents, probably what I'll do is dive back into the depositions. We'll just pick up where we left off because it's been a few weeks that we were doing those. Big Jeff had some personal stuff, real life stuff to take care of, but hopefully by the time we roll around to this, we probably will dive back into the depositions and give them another go. So anyway, anybody got anything else? Alice, you got anything to add before we go? We may have had Alice to sleep again. Susan, are you asleep or are you still here, birthday girl? Yep, Susan's out. She said she was tired. Asleep. Well, yep, we knocked him out with that last document. All righty. All righty. Well, that's okay. Yeah, she sounded tired.
She did.
Yeah. All righty. With that said, really appreciate everybody coming along and going through these last two documents. Appreciate everybody following us and what we try to present to the public for their own dissemination. And if you like what we're doing, hey, give us a like, subscribe, share, get others interested that you think might be interested in the case and other cases in the future. We'll just see where the road leads us. And we've got 2023 coming up around the corner here soon. So with that said, I'm going to say this has been a Foul Play production.
See you, everyone.